Item 72 listed today before your lordship was heard in part by Justice Somsekhar bench, my lord. And I had completed my submission before that bench, my lord. But in view of the notification dated.
Learned senior counsel.
No, my lord.
Learned advocate Mr.
Kumar Parimal, my lord.
Kumar
Parimal, Parimal.
appeared to state before the court that
My lord, may I make
the present, 1 second, present, it is, what is it, appeal?
Writ appeal, my lord.
Writ appeal was heard before.
No, but it is released from.
This is mentioned memo, my lord.
It is released from part.
It's released from part.
Yes, my lord. In view of the notification dated 11th March, my lord.
We can't do it.
So
It is
this matter will be heard afresh, my lord.
Yes, naturally, whenever it reaches, we'll take.
Just to save the judicial time, my lord, your lordship either may refer back.
counsel, we can't help once it is released.
Please.
That's the.
So, my lord, then fix a date, my lord, since I have come from Delhi, my lord. And yet, yesterday your lordship accommodated me giving it in another matter, my lord, 18th April. So your lordship may hear. 18th April, my lord. This matter was released on account of that 11th March notification.
It's all right. Before making such submission, you should have read the order sheet. Otherwise, suppose if we were swayed away by your louder voice.
Yesterday,
Promotion.
please, my lord. Eligible for 18th April, my lord. Yesterday, your lordships have given one date, my lord. Since I have come from Delhi, my lord, so just I'm making a prayer, my lord, that your lordship may fix on 18th April so that it would be easier for me, my lord.
This will go after vacation.
18th April, my lord, please.
Let's kindly.
We welcome everybody from Delhi, Kanyakumari.
No, your lordships are kind enough. my lord.
You should understand our difficulty also. So many cases are there. Pending
Since
pressure is
I'm coming here for 18th April, my lord, so it would be easier for me. I'm making a prayer, my lord.
very, we have said that.
You know that two matters will not be possible to be.
It is possible.
13th of June.
13th?
June.
Lords, kindly, my lord, one matter, my lord. The state, my lord, is recovering the additional stamp duty on the basis of the circular from the landowners who want to develop their property for the ameliorating their financial condition. my lord.
This can wait.
Lord, therefore.
This can wait. It
Pardon?
will come in due course. It will be listed.
Right.
Once you remove the.
This is a fresh
Yes.
matter, my lords. This is a fresh matter.
It
And,
will be listed.
several-
Fresh,
Yes.
fresh matters are meant to be listed. Why you are mentioning?
Achha.
No, not necessary. It will be listed once you remove the office of the. Yes, Mr. Yes.
But what registration of 95 RBC? Yeah, there was a moratorium is operating because of the
Registration of.
registration of 95 for the NCLT under the IBC is cut down. Only the resolution for it has a power.
Monday we'll have.
Monday.
Lordship, this is a writ appeal where we have now received contempt notice. Hence, there's urgency. It was for consequential benefit of promotion to be awarded. But due to the conduct of the employee, we are not able to consider promotion. Now they have filed contempt proceedings against it. We have received the notice. Hence, there's urgency in the matter.
So appeal is there. Your
Yes,
appeal
writ appeal. Monday, your lordship.
next week.
Monday,
Next Wednesday.
Wednesday.
Third.
May I make one submission? Serial number 47, my lord, it's a government appeal. And the order against which we have appealed is passed by my lord Justice Krishna Dikshit.
Not to be placed before the bench where one of us. 47.
47.
Anyway, already there.
44.
4 to 40.
44.
Obliged.
From Bombay. Other day,
Sir, be clear to VC, sir. You are not properly audible, sir. Any mention through VC, sir? Grant permission. Writ appeal matter, cell number 1, Mr. Keshu Bhatia.
Already appearing for, I'm sorry. But this is the grant of land. But actually, the Lordship may kindly remember, land is granted. Land is granted, my lord, on fixing a certain amount. My lord, we challenged that, my lord, by filing an appeal before the KAT, only to the extent, my lord, the amount fixed is on the higher side. But the appeal was allowed, my lord, only to that extent. Not, my lord, to any other. Kindly see, my lord, annexure B. Land is granted. Kindly see, my lord, the order of the KAT, my lord, in appeal. Page, my lord, ink page 27. Last portion, my lord. Kindly see para 10, my lord. Last portion, ink page 27. In the result, the appeal is allowed. The impugned order passed by respondent relating only to the amount fixed. Only to the amount fixed and payable in respect to the land in question is set aside, and the matter is remanded to the respondent with further direction to redetermine the amount payable of such amount at the rate of 200 times of the land revenue. So 200.
The amendment uses the word substitution. Therefore, yes.
Now kindly see, my lord, this rule, my lord, the learned single judge has said, my lord, on the other day, can I just pass on this? It's only prospective, my lord. Mammal submission is kind. 223A. But it is only prospective. It has no retrospective. It has not substituted any rule. Kindly see title and commencement. These rules may be called Karnataka Land Grant Amendment Rules. They shall come into force from the date of their publication in the official gazette.
I'm on the court. Making
Then, my lord, insertion of Rule 23A, my lord, then Rule 23A, grant of leased lands to the persons to whom the lands have been leased for the purpose of cashew cultivation, notwithstanding anything contained in these rules or any directions or orders by the government. The lands which were leased before the commencement of the Karnataka Land Grants Amendment Rules 2023, hereinafter referred to as these amendment rules, for cashew cultivation, and if the lessee has complied with all the conditions of the lease and continued to be in possession, the assistant commissioner of the subdivision shall grant the leased land to the lessee. But this is all in my favor, my lord. The authorities have held, you have complied and granted also.
No.
Then, my lord, the
Other
after
day-
obtaining an application,
Other day, not complete. Other day, you have shown another document which said substituted. We
No,
remember.
I have
The
not.
Foreign lawyers were here. One foreign judge was also here. They're very attentively, both we saw. Word substituted was there.
But substitute.
Which is that?
I'm sorry, my lord, I am subject to corrections. My lord, there are no such.
Our memory fails us, but not that much.
But this is the rule. This is the rule.
I vividly remember the word because I quoted Felix Frankfurter's judgment, Michael Kirby's judgment in Australia, Linlith Ghost's judgment in Ireland. I thought that day I quoted, you were
But
there.
your lordship
Yes, sir.
said, my lord, on the other day that it is substituted. My lord, I too thought, my lord, after verification of this rule.
Other day, he said, which is that? The word substituted was
No.
there. Otherwise, we would not.
But I'm sorry, my lord, this is the rule which governs it. And this has become final. Earlier, my lord, all that things have become final. That's my humble
But
submission.
that my lord gets it one substituted for the words on
Ah.
payment of 50% of the
Correct.
market value.
Where is that?
My lord, it's-
Paragraph
My lord, in rule 23 only,
23 only.
yeah, bottom. Substituted for the words.
So you yourself by approaching the tribunal kept the things.
My lord, at the
pending.
bottom.
In that rule
Yes.
book, yes. But
Well, this is the government notification. I have taken it out from the.
we'll look it.
Okay.
This has come into effect, my lord, in February 2023. That book itself may be.
Last time you had given.
My lord, can I mark it, my lord?
Yes, mark it.
Complete by approaching the
By
tribunal,
approaching this.
by disputing them. Otherwise,
But the word substituted appears to have been inserted by the author of the book.
My lord, notification,
Government
then I'll have to
notification
get
is-
the notification.
No, he has produced notification.
Hey, that is
We
of
were misled by
2023.
this introduction.
this is
This word.
amendment.
This is amendment.
See the government
Of course, we
notification.
are not finding fault with it because book itself says like that, as you rightly said.
So that author might not be that precise. as my
Therefore,
brother is. Absolutely. It's very fine distinction.
Yes.
Interpretation. of Amended and substituted.
substitute.
Yes.
In fact, in England,
Yes.
printing law books is an offense punishable with imprisonment. Only authorized persons alone are permitted to print. Otherwise, these things will happen.
Then the complaint-
You have read from the book. We are not finding fault with you at all. Even we have also read from the book only. But the bookmaker,
Yes.
it's called in Sanskrit Mudra Rakshasa. The
So it is the words.
print
group of-
Leviathan.
Group of words substituted. Condition is.
Changes. Only the author has done that. Okay. Law, it uses the word inserted.
So we can say this is prospect.
For his fact, he'll say.
You are right. We accept your.
Oh, very well.
I stand
Greatly.
corrected.
I'm sorry. There is a- To be corrected or not, there is only. Oblige.
Obliged.
Still number 2. The Naveen Chandra.
Appear for the petitioner, my lord, obtain contempt. My lords, this matter is with regard to the non-compliance and violation of an order of the Honorable Family Court dated 6th February to hand over the interim custody of the children who are aged 7 and 8 to the petitioner father. Now, my lords, if my lords recollect, initially when the matter was heard, the issue was raised that there was a stay order from the Honorable Supreme Court. And thereafter, my lords, in fact, mentioned that kindly get a clarification. We went to the Supreme Court. We, in fact, applied for a clarification and a vacating. And thereafter, the Supreme Court gave an order. My lords, may I just take my lords for a moment through the latest Supreme Court order, which I handed over yesterday, my lords. That is order dated 14th March. May I just refer to that, my lords, for a moment? I handed it over yesterday. If it is on record. I have one more copy, unfortunately. It is in the IA. My lords, I have filed IA number 2. It is in the said IA, my lords. If my lords don't have the loose copy of the, yes. In the IA, it is at page 173. I have annexed it.
Yes, last page.
Last page, I annexed it.
Last page.
Yes, please, my lords, may I just read out? Heard so and the order in contempt, my lords, that is at page
85.
47,
To 85.
47, and the operative portion
Is 85.
is 85, my lords are right. The operative portion, my lords may see, the order, I'll just read out the operative portion since my lords asked for it. IA2 filed by petitioner under section 12 of the Guardians and Wards Act is hereby partly allowed. Respondent is hereby directed to hand over the children, Master Tiago Monte de Silva Sidhu and Miss Inez Monte de Silva Sidhu, to the petitioner for completion of their academic year of education at Bangalore International School, Bangalore. Respondent is given visitation rights on Sunday whenever she wants with prior intimation to the petitioner without affecting education of children. During the vacation of the schools, the respondent mother is entitled to take her children with prior permission of the court. Respondent is also permitted to talk with the children on alternative days in phone calls through between 6 to 7 p.m. Both parties are advised to not give ill advice to the children whenever they are in their custody under the visitation rights. So, my lords, the direction was on 6th February that they were still studying here in Bangalore International School, which is in fact one of the premier schools in Bangalore. And the direction was, since she had taken them away and disturbed their education, and they are residing here, to bring them back and complete the education and during the vacation also be here. Thereafter, the court would decide further orders. My lords, till date, we are in end of March. The children have not been brought back. Thereafter, my lords, in fact, this order,
Where is that 6/2/2024 order?
that is the order, my lords. At page 85, what my lords read is the 6-2 order.
It's a contempt.
No. This is the family court order, which we are
You are here under
in contempt of this order. We are in contempt of the 6th February order, which in fact, if my lords would see the last page, the order of the Honorable Supreme Court, the Honorable Supreme Court notes that this order was not even intimated. May I just submit, just to clarify, 6th February order is passed by the Honorable Family Court to direct the children to be handed over to me. Mother has taken them away on 1st of December to Goa. Mother, may I just submit, my lord?
Yes.
On 1st of December, the mother has taken them away to Goa after she was found on 25th November. In fact, at page 35 onwards, 25th November, she is found in her house with another man in her room. Thereafter, she runs away to Goa alone without children. She comes back on 31st, takes the children on 1st December, disrupting their school. 6th February, the Honorable Family Court passes an order that hand them over. Then she goes to the Supreme Court, files a transfer petition. In the transfer petition, an order is passed, stay all further proceedings in the family court. At that time, the 6th February order is not informed to the Supreme Court. Then when we file a contempt, my lords say, please kindly get a clarification before the Honorable Supreme Court whether we can continue.
That we have understood.
Yes.
And, now we can proceed.
Yes. Now I just want to add to that. When we filed an application in the Honorable Supreme Court as directed by my lords, to that application, the respondent mother files her objections In her counter, which I have produced, she says the Honorable High Court of Karnataka has never asked for such a clarification, despite them being here. Thereafter, the Honorable Supreme Court passes an order that this was not intimated to us, and this Honorable High Court can go ahead. Now, my lords, the reason I bring it up is that all of this was done. I wanted to just show, my lords, that ultimately all of this is done to ensure that they continue with the contempt, and she does not hand over the children. Now, my lords, kindly see.
What is the age of the children?
My lords, the children are a girl and a boy. The children are aged 7 and 8 years old.
7 and 8.
Yes. And they have been, in fact, residing right here with the father. In fact, mother was also residing here. They have been studying in one of the premier schools, which is Bangalore International School, in fact, where they are continuing their admission, which they have been deprived of. And my lords, these...
Who
I know that...
Right now, the children are where are?
They are
children
now in Goa, admitted to a college school, and they are continuing their education there.
That would be a blatant
Yes.
breach of this.
No,
order.
that was prior to this. I'll state some dates, Lord. Lord, please take a petition filed by my learned friend.
Whether this order is put in challenge.
It is challenged before your lordships, my lord. The writ petition, yes, writ petition which I have filed 6121 of 24. In fact, my lord, when the contempt petition was moved before this honorable
Writ
court,
is
I am
connect-
told that your lordships, my lord, indicated that the writ petition could be called.
6121.
Yes, 6121 of 24 is
My
my
lords-
writ petition challenging it.
My lords, now may I make a submission, my lords? Yes. My lords, could I make a submission? A writ petition,
170.
could I make a submission, my lords? A writ petition is filed by the respondent mother on 15th or 16th of February to challenge that order. And writ petition is pending, there is no stay, contempt continues. Now, my lords, I want to put a submission. The rule on contempt, and I would like to raise this very categorically with my lords, the rule of contempt follows the Atkinson orders rule, which Lord Denning had passed, which even our Supreme Court has followed, that when there is a contempt, and this was in fact in the case of child custody orders, but it applies to all contempts. When there is a contempt and the contempt is continuing, even if there is an appeal against the order complained of, unless the contempt is purged, the party cannot be heard on merits on the appeal. And my lords, I would like to pass on that. They may very well file a writ challenging the interim custody order, but that does not allow them to continue with the contempt.
But the
And-
council is probably trying to say that before the date of passing of the order, they were admitted in Goa school.
Yes, my lord, and there's an order passed, there's an order passed by the competent court in Goa under the Domestic Violence Act, directing that the custody should be with the mother in Goa.
There is
What
no,
order
there is
we
no
can't,
custody order in, there is a custody.
Look into.
No, there is no custody
But
order.
they're concerned with the contempt of this order.
Yes, my lord.
Now, if you are able to demonstrate
Yes,
that the substratum of compliance is not possible,
yes,
or it is not intentional.
Yeah.
Since the children were already admitted in Goa school.
Yeah.
Then it's a different story.
no, my lord, that's why I'm submitting, my lord. What happened in the sequence of events was, the writ petition was before the learned single judge, my lord, roster judge, who was dealing with family court matters. The contempt petition was moved before your lordships. And at the time, my lord, your lordships directed that writ petition to be called before your lordships. That is how, my lord, that writ petition 6121 is before your lordships. Now, my lord, in the contempt petition, I would like to file my counter to place all these facts. But if your lordships could please see, my lord, in writ petition 6121, where I challenge the order of the family court, lot of information, my lord, which has not been placed by them, I have placed. My lord, what happened in this case, my lord, the parents of both the boy and the girl, the husband and the wife, they live in Goa.
It's false.
They,
No, I'm sorry, my
Please
learned friend
submission.
can continue, I'll
if you want
respond
to
later.
continue, I'll sit
No,
down.
no,
My lord, the marriage took place in 2015.
Date. May
At
not be. the same.
11th of
We
February.
are not on validity.
No,
of
my lord,
the-
I'm just giving.
The-
in
the
two-
two children begotten from the marriage.
Yeah.
Both are boys. One
No,
is.
Boy
and
and
a
girl.
boy
One
and a
boy,
girl.
one girl.
One girl, one boy.
Both, all of them were living in Goa. right up to 2021. Then, my lord, this couple moved to Bangalore. But the boy's parents still live in Goa. The girl's parents also live in Goa. Now, my lord, there was some discord. So the children, my lord, were taken to Goa and admitted to school in Goa by the mother.
When they were admitted?
Yeah. No, my lord, they left, my lord, in November of 23.
Both were admitted.
Both
My
were
lord,
admitted to
before
school.
admission to school, what happened, my lord?
Both
was
were
this.
admitted.
Yes, both are admitted. My lord, before that, what happened, my lord, was this, that the mother filed a domestic violence case
In
before
Goa.
the competent court in Goa. The honorable court there, my lord, passed an order on 6th of December 23.
My lords, if you're hearing on merits, my only submission is if my lords are.
These are all custody matters. We have to be little leniently consider all of, not some
Of course.
property dispute.
No, of
Therefore,
course,
we
certainly.
will not pass any order without hearing you.
No,
We'll
but
hear you.
since I'm the petitioner, let me at least present the facts before the respond.
Lord, let the writ petition then go back before the learned single judge, my lord.
Why?
No, I'm only saying, my lord, if they don't want me to argue at all.
No, there is no difficulty. Of course, I cannot stop my learned friend from arguing, and I'm not even opposing
That's
his
what you're doing,
arguments.
madam.
No, but
You're not
I'm
allowing me to
only
complete my
seeking-
sentence.
I'm only
The
seeking.
defense of the other side in your writ appeal is also an answer to this contempt. So that is how it is.
That's how one division bench said like that. Writ petition was one division bench of our High Court, Justice Hakim's bench said like that.
The order of the domestic violence court, my lord, is produced in the writ petition. If your lordship kindly takes WP 6121 at page 80. The prayer is there and the text of the order is at 87. This is my petition, the mother's petition.
No, writ petition.
No, in the domestic violence court, my lord, a petition under section 12 is filed.
No, that is part of your writ
In my
petition.
writ petition, yeah, sorry. In my writ petition, 6121,
Yeah.
page number 80. The prayer is at the bottom, my lord, C.
Orders maintaining.
Orders maintaining the custody of our minor children, so and so with the complainant, and orders restraining the respondents and all persons claiming from or through them from forcibly taking the minor children, so and so, out of the custody of the complainant and from taking forcible custody of minor children, so and so. This is the prayer. At page 87 is the text of the order. It's in manuscript, Lord. There's a typescript also is available, 170. 170, my lord, is the typescript. Issue notice to respondents.
In the meanwhile, ad interim ex parte
Yes.
order,
At prayer C is granted till next date of hearing.
prayer C is granted till the next date of hearing.
This is pending
This
and
was-
the interim
this-
order is continuing.
This order is
Yes.
continuing.
Now, my lord, in the meanwhile, the husband, my lord, moves a GNWC guardianship petition before the family court in Bengaluru about 8 days after this order is passed. He files the petition on 14th December 23. The honorable court that your lordships will get at page 91 annexure D.
Page 93.
91, page 91 annexure D is his petition under section 25.
Petition and
The prayers in that petition, my lord, are at page 1. 31. 131, Lord. 131, bottom of page 131. Allow the present application under 12 of the Guardians Rights Act and grant sole interim custody of minor children so-and-so to petitioner. Then there's an alternate prayer, grant visitation rights. On this, the family court issued emergent notice. That order was challenged before the Honorable Court in a writ petition.
No, this was filed on which date?
14th of December 23,
14th of December.
dated 13th, but filed on the 14th. The date your lordships will get at 91, seal of the court.
14/12.
Yes.
After
23.
Goa order.
Goa, after the Goa order.
Whether, does it mention Goa order inside?
Not mentioned.
Are you sure?
Yes.
Mentioned? Is it mentioned?
My lords, I'll just make a submission.
Anyway, my lord, the learned single judge did not entertain the writ petition and only observed that it is appropriate for the family court to hear and dispose of the application.
No, that's all right. Whether 6/12/2023 order says, it says, obviously, ex parte.
Yes.
Whether was it communicated to them?
Yes, it was communicated there.
When it was, how, when? How and when?
My lord, your lordships may please turn to page 89. They appeared in the court.
On.
Yes. And there was a joint memo filed
All
on
that may not-
21/12/23.
Our specific question is 6/12/2023 was an order issued ex parte the complainant.
Yes.
When that order was communicated, this question assumes importance
Yeah.
because conduct of the party we have to see.
Yes.
And the petition having been filed on 14/12/2023.
Yes.
Before ink on the order dated 6/12/2023 had dried up.
Yeah.
What we want to know is
Yeah.
when they were communicated.
I will, my lord,
Yes.
just verify the record and make that submission, my lord, in just a moment. But could your lordships, my lord, please turn to page 89. What happened shortly after that was they appeared before the court in Goa.
Before you proceed, what happened on 15/12/23?
Yes.
On
That is
15,
the important
15/12/23, this petition, my lord,
No, the order at page 88 refers some events having taken place on
Yes.
15/12/23. In that light, the respondent did not hand over the custody.
yes, no.
Yes.
So that gives at least the background of the
Case.
conduct.
Yeah.
There is an order passed by the court on 15/12/20.
Yes,
May
my
I
lord.
just submit on that order, my lord?
Let's let him go.
Very well.
We'll revert back to it.
What was this order?
No, that is an answer. Where is it in theirs?
I'm told, my lord, that the honorable court in Goa had made an order that the father should be able to take the children for some sports meet or something. After hearing them, court had directed that father should be able to take the children. After that, this memo was filed.
Is it the only thing, or it might be one of the things, or it also transpired that the children wanted to go with the father?
I will, my lord, that order is not on record, my lord. I can place that
We
before
have
you.
placed it on record in the contempt. It is at page 224.
Placed it on record. Page number?
224, my lords, in the contempt paper book. The 15th December order is there. At page 224, the father appeared and asked for taking the children for 3 days.
Page
Sin-
number?
Page 224, it starts, my lords. It starts at page 224 because they had sports day in school. My lords, may just read the first para, if I may just read out the first para at page 224. By this order, the court shall decide the limited relief of temporary visitation rights filed by respondent 1 to sought by respondent 1 from 1512 to 1712 to enable children to attend sports day in Bangalore in their school. And ultimately the court passed the order at page 233. In fact, here the court at page 232, para 20, may I just refer, I brought to the attention of the court there that I had already filed GNWC proceedings because at that time I didn't know about the DV court proceedings. My lords may see at para 20 at page 232. What the DV court says, respondent 1, as per his own submission, has also approached before the family court in Bangalore for seeking custody of children. Considering the temporary nature, the order provided under this act, this order in any ways will not come in the way of the parties in seeking any nature of custody before the family court Bangalore. I pass the following order. At page 233, the court passes an order that respondent number 1 is granted access visitation rights for 72 hours between 1512 to 1812 to enable the children, master so-and-so, to attend sports day in Bangalore on 1612. Respondent is directed to bring the children back before 1812 and hand over physical custody. He is directed to provide flight and travel details. I had given my flight tickets, which I had booked for me and the children. After this order, I was not given the children. Despite me giving flight tickets, I booked tickets for children. Children were not handed over to me. Despite this order, I only saw them for a few hours in Goa. I stayed on there. I filed a contempt after this, which is pending in the appropriate court in Goa. Then, my lords may also realize that when in the present proceedings before the guardianship court, my lords, even the impugned order here on 2 dates.
You are the mother.
I'm the father, sorry.
You are
I'm the father. Mother took
Then
the...
page 233. What is this present application is granted with respect to prayer? What is that prayer?
My lords, I had just made a prayer that the children had sports day in their school.
Where is that prayer?
That application is not produced. It was a limited application to just take them for 3 days to
Sports
Bangalore
event.
for sports day in school. They were taken away from their school. They had sports day where they were participating.
They wanted to take her.
The father wanted to bring the children back so that they can attend their sports day in the school where they are admitted. And in fact, they're continuing to be admitted. So I went to Goa. I said, let me take them for 2 days, 3 days. I will give a return ticket.
No, mother.
Children, my lords, children were in the middle of their school year, taken away by the mother.
Those proceedings were instituted by the mother.
Yes.
And in that you made this application.
I made one temporary application that allow me to take the children for 3 days to Bangalore to attend sports day, which is part of their school. They were deprived of it. And in fact, the court said, get me the tickets. I bought the tickets for all the children and me.
He did not. She did
And
not.
after the court said, unless you bring the tickets, we will not release. What if you don't bring the children back? I brought the tickets.
What happened to those proceedings now?
Now, my lords, after this, there was a contempt. I filed a contempt. Then I got then every time I want to see the children, I went there. I got again 1 or 2 orders. Those proceedings, the respondent mother is carrying on. Ultimately, my lords, under the DV Act, it is an act to protect women. And these are only temporary orders of relief that the mother can get or I can get if I want. I filed a comprehensive guardianship custody case in Bangalore because children are ordinarily residing in Bangalore. And I got an interim order. My lords, I want to just point out the reasons of the manner in which even in the interim order, my lords, ask the question of conduct. When
I think that clarification my lord wanted.
Yes.
We'll come back to you after.
Certainly.
Yes.
Lord, now please not turn to in my writ petition.
Yes.
To page 142. I have narrated, my lord, what exactly happened in the domestic violence proceedings. Page 142. Para 8. that on 14/12/23, the petitioner herein appeared before the above case and filed an application under 28(2) for protection of women from Domestic Violence Act, seeking dismissal of the case alleging fraud, material concealment of facts. The petitioner also filed another application seeking custody of the children.
Where you reading?
Yes.
Reading where?
Which paragraph?
I'm sorry, not page 142, paragraph number 8. That on 14/12/23, the petitioner herein appeared in the above case, filed application under 28(2) for protection of women from domestic violence, seeking dismissal of the said case alleging fraud and material concealment of facts. The petitioner also filed another application seeking custody of children from 15/12 to 18/12 for bringing children to Bangalore in the event of sports day of school, and also with another prayer to visit children and an undertaking before the court in lieu of the undertaking given by the petitioner herein. He was pertaining to meet the child on 6:30 p.m. at the open space garden opposite so-and-so Margao on 14/12/23. In view of the undertaking given by the petitioners, the interim order with respect to not taking forcible custody of the minor children from respondent herein came to be extended till further orders. The respondent also submitted to the court that she had no objection for petitioner making the children as long as the jurisdiction in the state of Goa. The case was adjourned to 15/12/23. Respondent submits on 15/12, petitioner filed statement of objections. Honorable Court passed detailed order permitting petitioner to bring the children to Bangalore for sports day as under. The operative portion has just now been read, madam. Then
The
page,
court said,
so then, my
the
lord,
Goa court said
yeah,
that the father should take the children
yeah,
to participate in the sports event at
Bangalore,
Bangalore.
yeah,
And on 18/12, the children should revert back
yeah,
to the lap of the mother. That was the order.
yeah.
But you are saying in Goa, I will permit them to take, but outside Goa, I will not, though those words are not there. The impression that we gather
Yeah.
is that you have violated the order of the equitable order of, it's an order in equity.
My lord, that was remedied. If your lordship should turn to page 89, both parties agreed on a visitation after that date happened. My lord. Please turn to page 89. There's a joint memo that is filed.
8/9.
Yes, 89. It's filed by the father. Without prejudice to the rights and contentions, the applicant father and respondent mother have agreed to the following arrangement for exercise of visitation rights.
This is filed on
21/12/23. Take it accordingly.
Yes.
These dates, my lord, visitation did occur. Even now, my lord, I have no objection if they come and spend time with the children in Goa because his parents are also there. My parents are also there, I am also there. No difficulty to offer visitation rights there. But the impugned order, my lord, directs me to hand over custody of the children to them, to the father.
this memo is the period specific.
Yes, my lord, specific dates. Yes. I am saying, my lord, now also, my client has no objection for the father to spend time with the kids. But children should be in Goa. And the question whether Goa court has jurisdiction or the Bangalore court is now before the Honorable Supreme Court in a transfer petition. Transfer petition notice is ordered and is pending.
But apex court said there is no impediment for us to.
That's
treat
true, my
the
lord.
matter.
I'm not saying that your lordship should not. I'm only saying, my lord, as a matter of fact, that since the family court, the domestic violence court in Goa has been invoked, and we have sought transfer of this GNWC proceeding to Goa, that being seized off by the Supreme Court, as to which court should ultimately pass an order will be left to their lordship's discretion.
One child is 7-year-old,
Yeah.
another is 8.
Yes. 15, they were born in 2015 and 17.
Yeah. Before that, where the children were studying?
My lord, they were studying initially in Bangalore only.
Bangalore.
Yes.
When did you take the children to Goa?
In
Which
November
date?
23. On 1st of December 23, my lord, the exact date is when the children were taken to Goa.
Any observation as to the way the mother conducted with the children?
For her own
It
moral
is,
conduct.
it is there.
conduct.
Yes, it is there. May I refer? May I submit?
No, you're asking, we'll come back to you.
Oh,
Just
I'm
we
sorry.
wanted-
I thought my
There
lord
is
was
an
asking.
allegation, my lord. A serious allegation is made that some male member, one friend, was found in her bedroom in a naked condition. That is the allegation they made. That has been completely denied. It is not true at all. And they have produced material to show that that person was only a family friend and he is a homosexual. He has himself filed an affidavit to that effect. And he has no relationship with her. We have denied all of that.
That's all right. On what ground the impugned order is made now?
Two
What are
grounds,
the
my lord.
two
Yes,
grounds?
your lordship.
One first ground is?
Yeah. The first ground, my lord, is that the father has spent 8 lakhs of rupees and paid school fees. Annexure J at page 176, my lord, the reasons your lordships will get at page 196.
Father has already paid amount and admitted
Yes.
the children to
School here.
by paying 8 lakhs.
Yes.
Which
8 lakhs
school-
rupees.
when the admission was done?
Your lordships are asking Goa or Bangalore?
No, Bangalore,
Bangalore was earlier itself, my lord, in July 23.
in July 2023.
After the mother moved to Goa,
No,
She
that
had-
was November. She moved in November
yes,
2023.
yes.
Much
After
before.
that, the children, my lord, have been admitted to school in Goa also in January.
That's all right. July 2023 admission was done. Were you taken in confidence while making this?
Yes, at that time, they were both living in Bangalore only.
So
harmony there.
you knew and you tacitly agreed that admission should take place.
My lord, at that point of time, my lord, there was no estrangement. there was-
Estrangement began when?
It began, my lord, only towards the end of November.
But generally spousal estrangement will not erupt like a revolution, like hurricane is the law.
Maybe there is something, my lord, which is simmering, but what is on record only is something which I can place.
I only said from what Bertrand Russell said in his famous book, Marriage and Morals. I just quoted it, that's all.
So now the question that falls for kind consideration, my lord, is this. Was the learned family code justified in directing the children to be brought to Bangalore and given to the custody of the father?
No, first ground you said, father has already admitted the children way back in July 2023 and you tacitly agreed for the same.
Yes.
Your contention is there was no eruption at all
Yes.
at that time. Second ground is?
The second ground, my lord, is that there is an allegation
Of the which one you mentioned, need not
relating to.
repeat,
Yes.
same thing. That is held to be demonstrated.
No, the learned judge only refers to that. That's all. He doesn't reach any finding. Learned judge says that there is such an allegation is on a record.
Which is the paragraph?
Page
We will-
196, para
You
35.
need not loudly
Yes.
read it, we'll read
Page,
for ours.
page
number?
196, para 35.
Page number?
196. Para 35.
Paragraph?
The next portion, my lord. What
35.
I'm drawing attention to is page 196, para 35.
Para is 23.
I'm sorry, my lord, there is some confusion with
Confusion,
regards to page. Sorry.
Which is that page?
My lords may refer to that in the contempt if my lords wants the same para
Para
number.
35. My lord, my learned friend says it may be in page 205. 205. Para 35.
Kindly come to para 35.
Yes.
Fifth line.
Yeah.
3 words are there, 4 words. In his bedroom.
Yeah.
He also resides in the same house. No.
No.
No. Does he reside in the same house?
No, no.
Is he a
This
visitor?
gentleman resides in another house in the same layout.
Yeah.
They live in a layout. He is found in this condition in my wife's bedroom in the night. When I knock on her door, she doesn't open the door. And when she opens, this gentleman is found in such a condition and he runs away at 11 p.m. in the night. And that day, the court notes, immediately the next day, she leaves to Goa without the children. When this has been discovered on 25th night, 26th, she leaves the children, leaves the house without children. After 4 days, she comes back with her mother. And on 1/12, she takes the children forcibly as soon as they return from school. When I'm at work and I'm not in the house, my parents are in the house, my elderly mother is there. She calls me and then she runs away with the children to the airport. I go to the airport and try to take the children. I'm unable to do that.
There is an explanation to this, my lord.
Para 35 is argument.
Yes, that's the learned judge is noticing that there
The
is.
finding with regard to argument and counter argument.
Yes, my lord. Kindly
Which
now, my lord,
paragraph?
permit me to go forward in the same order. At para 41. May I read not a few lines before para 41, that is the last 5 lines in the previous page. Whether who
photographs.
is entitled,
40 onwards.
Photographs.
it's at the end of para 40. Internal page is 34.
If it is not a happy reading, we will read to
No, no,
ourselves.
I can read this.
If there is no such thing, then we can loudly
ma'am.
read.
This
because
can be read, ma'am.
Many children also will be
Yes,
seeing
section.
the court
Yes.
proceedings. Therefore, if there is such thing,
Please,
which we
ma'am.
can read to ourselves,
Fair
just
enough.
indicate.
Yes, ma'am. There's no difficulty, ma'am. I'll read this. Internal page 34, last 5 lines. Whether who is entitled for sole custody, it has to be decided after full-fledged trial. Considering the facts of the case regarding the respondent has taken the children without informing petitioner and his parents to Goa. She has admitted the children in Goa as she has produced 2 receipts dated 16/1/24. The children were studying in a reputed school and petitioner has also paid huge amount for their admission. Until 26/11/23, he has taken care and welfare of children. There is no single allegation regarding harassment by petitioner to children. Therefore, considering the facts of the case and documents on record, at this stage, interest and welfare of the children has to be looked into. On 1/12/23, children were also not attending school. The dispute between husband and wife, but children were suffering. If the respondent had love and affection for children, on 26/11, she left alone to Bangalore. And after 4 days without information, she came to Bangalore, took the children. Itself shows her attitude. And without taking consideration of the welfare and education of children, she took them away from Bangalore. She has not at all considered academic care and education of children. Petitioner is capable to take responsibility of children and his parents who are also residing with him. That may not be correct. Then respondent has produced admission form of both children on 16/1/24. It appears there's a loss of education from 1/12/23 to 16/1/24. The fee paid by her is 37,000 each for children. Then what next para is about some technical thing about 2 prayers, etc.
The parents last resided together up to what point?
Up to the 23rd of
26 November.
26 November. 26 November 2023.
Where is the finding with regard to paragraphs argument in 35 and argument in 36?
No finding.
40. May I read out? Para 40.
40.
Yes, may I please read out? And if there is anything sensitive, I will not read out. Para 40.
We'll read 40.
Yes. No, there it is. Yes, it is.
We will read to ourselves.
Yes. No, it is quite fine, my lords. 40. It is an admitted fact that respondent is not doing any work. Petitioner has produced the communication between petitioner and so, as well as on the date of the incident, he came to the house of the petitioner. Screenshot of CCTV photos were produced to prove the incident. Petitioner also produced air ticket of respondent only, which was dated 26/11, because initially she went alone. The photographs are also produced regarding visitation rights enjoyed by the petitioner in Goa. That is when he went later to Goa. The main contention taken by the petitioner is that even though court order is for visitation rights as well as to attend.
Paragraph 40 does not speak of one word about the incident. Go to the next paragraph.
Yes, I mean, to the extent that it says CCTV photographs are produced.
That is
air
not
tickets-
with respect to that.
I'm sorry, just want to clarify that CCTV is for that incident, just to clarify. Then, my lords, even though in the present case, 2 times a direction was given to the respondent to keep the children before the court, but it was not complied by the respondent. The attitude of the respondent.
Now, if 2 grounds are, if the temporary custody is structured on 2 grounds, and one ground does not appear to have been treated by the court, because very important ground it is, which touches moral turpitude of the parents, which will have some bearing on the upbringing of the children in our society like ours.
Yes.
That there is no specific finding at all, number 1. The second will be, father had already admitted the children to the school way back in July 2023.
Yes.
July 2023. That will remain as the ground. And he has spent 8 lakhs, etc. That alone will remain as the ground now.
Yes, just briefly, my lords are right that on the moral issue, the moral turpitude of the parent has not been addressed. And in fact, I want to bring it to the attention of my lords that we have filed a writ, which we have just got an FR number, because many of these factors have not been considered. And in fact, we have filed a writ to modify this interim custody order to extend, because the whole point is, my lords, this order is only till the end of the academic year. And the mother has succeeded in ensuring by the contempt that the academic year will also slowly, unless the orders are passed to bring back the children, it will be completely rendered infructuous.
Where is your client employed and
He
residing?
is employed here. He is here. His parents are
Bangalore.
also here.
Please ask them to sit down.
Sorry.
Let them sit down. This is a court hall.
I'm sorry.
After all, it is for litigants only.
I was
Yes.
not aware. So he is residing here.
What is his vocation?
He is working in the Bangalore airport.
International.
Bangalore International Airport.
International airport.
Airport.
Father is retired.
Yeah, father is a retired army officer. His mother is a school teacher, was a school teacher. He is working in Bangalore International Airport.
In Goa, is there international airport? We want to know.
Must be. Yes, I think
You
there
have
is.
New international
I think-
airport in North Goa now.
I think there is.
How long he has been in this Bangalore International Airport?
I think he has just joined it, my lords. I think this was a new job. I think few months back he has joined, but he has always been working in Bangalore. He's a employed person. He has been employed in different companies. As of now, he's working here.
No, we are just thinking, case if it were to be some property or Team Bhiga land, perhaps argument would have been that way. But when the career of the small children is involved,
Yes.
if this war of Plassey continues between the parents, then what the impact it will have on the mind of the children is also to both of you,
Of course,
to us also.
of course, it's to this court, to us. In fact, my lords, our only submission has at all points been that the children should have an environment of stability.
Correct.
Whatever the issue is between the parents,
Parents.
children should have an environment of stability. That is the only way that even if the parents ultimately get separated, the children will be able to handle it. If the children are shunted around, my lords, in this casual manner, the parents, both the couple was residing in Bangalore for the last 2.5 years. They are staying in they were staying in though money is not an issue, they were staying in one of the most well-known societies, layouts. Children were, for the last 2 years, admitted in Bangalore International School, where they were continuing to study. And after this incident, whatever, the honorable judge has not given a finding. In fact, that is why we want, because on children's overall custody, moral turpitude is a very important issue. The mother,
That's not.
that is not, yes.
Finally, where they stand admitted as on the.
Now, my lords, our submission, no, my lords, allow me to
Go on.
kindly submit. Allow me to kindly submit. Allow me to kindly submit, though my learned friend has stated this. My lords may kindly see at page 121. Kindly allow me, sorry, my lords, I'm referring to my contempt petition. I'm referring to my contempt petition file.
From what is fallen from the honorable court, I want to make a submission, Lord, on my own.
My lords,
as
let
counsel.
me make a submission.
I'm saying, Lord,
Generally,
whether
we would have followed that pattern, since in family matters, courts will be more like the patria
Parents
parentas.
patriae, yes.
That way.
no,
Therefore,
what I'm submitting is slightly different. What I'm submitting is, they were, after all, 8-9 months ago, they were together, my lord. One attempt at mediation in Goa, my lord, may work. That's my feeling, my lord. As an individual, I'm speaking, my lord, not as counsel. We have not sought instructions, but my feeling.
It was attempted and failed.
No, my lord, I don't
Not
think so.
attempted.
No mediation ever took place.
It has not been attempted.
Would like to.
Is it not worth the?
My lords, we have always been open to any conversation to discuss the welfare of the children. There is no difficulty in having any conversation. But my lords, let the children be brought back. This is happening as a contempt, that the children come back to their school, resume. I want to show my lords ask the question, where are they studying?
For mediation, we can call the children also.
My lords,
speak to the children.
My
we
lords
have
can
little idea of child psychology.
My lords can
also.
certainly do that. My lords in parents patriae, my lords are well aware. My lords have to look after the welfare of the children. My lords, what has happened from 1st December is that despite me having orders in Goa, in Bangalore, I have not been allowed to take the children. Interim orders have been passed. I'm not allowed to even speak to the children. From the last 1.5 months, my lords, I'm barely speaking to the children on the phone for 3 or 4 minutes every day. Ultimately, this will amount to tutoring the child away from me. Unfortunately, that should not be done. But when the children don't have access to the other parent, and one parent completely, my lords, ultimately the children are being harmed.
You go to your house here?
Yeah, in Goa, yes.
In Bangalore?
Bangalore, she doesn't have. She was
How long
living,
you stayed in Bangalore?
my lord, from 2009, 2015 up to 21.
So Bangalore is a familiar place
21.
to you.
In 2021, the couple shifted to Bangalore.
First time.
Yes,
Shifted
up to
from?
2000, from 2015 to 21, they were living in Goa. Children were born in Goa. Her parents lived in Goa, his parents also lived in Goa.
Even now, his parents live in Goa?
Our impression is, my lord, information is that they are in Goa only.
They are here.
They are residing in
They are
Bangalore.
here. They're residing with him.
Which date the parents came to Goa, the Bangalore?
To Bangalore. Just go ask.
And why? Because son is employed.
Son is employed. Both are retired. Parents are both retired. Parents are staying here with him.
Since how long parents
I'll
have been
just-
staying here?
No, but just find out when they came.
Question is pointed.
When they came, my lords asked.
When they shifted their residence
To Bangalore. I will just.
and what is their background?
My lords, his father is a retired army officer.
Army officer.
And for 25 years, and his mother was a principal of a school.
School.
And she is also retired. So, my
Came
lords,
to Bangalore
when they came. They.
No, when the father.
When did the parents move? 1 minute, I'm sorry. My lords, they came in November last year.
November.
Yes,
After,
before this.
before she left.
Yes, before. In fact, before she left, they were here. In fact, I just want to clarify, on 1st, she left on 26th alone, without children. On 1st, she comes back, takes the children when the mother is there alone. Mother and father are there. The husband is at work, and the parents were very much there.
Do they own a house in Goa?
They don't own. They just have some rental.
Parents do not?
No.
No
Her
house.
mother owns a house.
Huh?
Wife's mother owns a house because wife's mother's side is originally from Goa.
Where they own their house? Because you said 25 years he was in army service.
Huh.
Really, they will have that benefit. Let him, he must have had.
My client's mother has given some land to the son-in-law also, gift deed. That was, of course, at a time when.
They don't have a owned property. They stay in rented properties.
They don't have any property in Goa?
No.
No property.
No, they don't. In fact, my lords, maybe my lords are asking that if she were to come back with the children, my lords, my lords asked about the education. The education, children are admitted here. In fact, at page 121, both their admissions are there, if my lords may just see, in Bangalore International School. That admission is continuing. Their academic year goes on to first week of June. Let their academic year not be disturbed. These submissions that they are admitted in Goa, my lords, my humble submission is it's wrong. It is, in fact, they have got some admission for the next year, and they have in fact started proceedings to my school to ask for a TC, which they have not got because they have continued.
Understood. What is the cause of estrangement?
My lords, for us, for the husband, the only cause of estrangement is that incident which happened. There was no cause of estrangement. They were living here. 25th was her 24th. One day before was her birthday. They, as a family, celebrated the birthday together. 25th night, this incident happens. 26th morning, she leaves. 26th early morning, my lords. Kindly for a moment, 1 moment, page 136. I will not take more than 2 minutes. Kindly see page 136 of my contempt petition. I'm referring just to my contempt petition. At page 136, after the 25th night incident, 136, my lords.
They married in which, how long they have been happily married?
My lords,
2015.
my lords, about 7,
2015.
8 years, yes. About 9 years. About 9 years. My lords, kindly see page 136. On 26th, early morning, after that incident has happened, the call and chats with that gentleman's father, who also happened to be an army officer and their neighbor. My lords, I will not read out, but my lords may read from the 4th or 5th line, where the petitioner is Shardul. He is messaging the father of that gentleman. I don't know if an apology cuts it, given your son was so and so. He says, I understand. And then kindly see at 9:03 a.m. he says, we are also very disturbed. Could we meet and speak? Can we meet? The father of that army officer, in fact, admits it.
Father, is he an eyewitness to admit?
I'm sorry. No. He not admits it. He was obviously not an eyewitness. But he's
responding to your.
Yes. I'm only producing this to so that immediately I contacted him because he was our neighbor and we knew him very well. Then he says, can we meet at your place somewhere? Then they met, and they also had a discussion where the parents apologized for what heinous incident had happened. Then can I briefly call you first, my lords? Then maybe till the half of the page. Then, my lords, may see page 138. I have a chat with my wife's mother at page 138. At page 138, about the 10th line, 26:11, again on the neck, immediately at 12:52. That is the night of late night on the same day, 138, my lords. At about the 10th line, the time dated 12:52.
Father of that person.
Yes.
Your client knows each other.
They know each other because they are all neighbors. They are living, he is an army officer, he is living with his son, and they are neighbors in the society. And I know his son, who's barely 20 years old, and I find him in that situation. And my lords, kindly see at page 138, I call my mother-in-law, who is the respondent's mother, and message her. And there I say about the 10th line. She says, she's not even taking her mother's call. And then her mother says, put her in the first flight out and send her after that incident has happened.
It appears that this is the only incident which precipitated this.
For us, this is the only incident. In fact, after this incident, 25th night incident happens. She locks herself in the room after she's found. Next day morning, she leaves everybody and goes. And she takes a ticket and leaves. That is the incident, nothing else. And then, my lords, may kindly see at page 208. Page 208. That is the only incident. At page 208, she books a one-way ticket for herself, just one person, and leaves for Goa. At page 2112, she comes back. And my lords, if that is the only incident, my children cannot be subject to that. She may, if she decides to do whatever she wants, my children cannot be subject to that. Children are studying here. Children have a stable home. And children, in light of that stability, the interim order is passed. If that interim order has to be heard on merits.
One of the photographs produced by you.
Yes.
4 children are seen. Who are they?
Other 2 children?
There must be the neighborhood children, my lords.
Just we want to know.
Yes, no, there are only 2 children. In fact,
One, we have seen 4 children.
my lords may, just wondering which page my lords were referring to, I will clarify. Could my...
Their neighbors' children.
Neighbors' children.
In the community, my lords, the neighborhood. The children are well set in the locality. My lords may tell me the page I can then. In fact,
Your client's parents also are in Bangalore only.
yes, yes, they're living in the same house. They're living in the same house. My lords, the children have to be brought back and handed over. My lords, I have also filed a writ if this family court interim order has to be re-examined. Then even my issues on moral turpitude and all those conditions I have raised, that even visitation, can it be given in light of these moral allegations, which are serious to children? And so my only submission, in fact, my lords, I gave the judgment of Lord Denning just because my lords also, yes, my lords, the only issue is ultimately first the contempt has to be purged. Both the writs, I will give my writ also. They can be heard either with my lords or the jurisdiction court. We are in my lord's hands. But the contempt first has to be purged. Children have to come back. They are not studying anywhere. They have an enrollment here.
How is their progress card in Goa school?
They have not been enrolled. Can I just show my lords the document submitted by them? Kindly see the application.
Going to school, yes.
No, the progress card of the children in the school. Do you have that progress card with you?
No, don't miss.
Too early, my lord. It's from 4 weeks onwards, they are going to.
Just now.
January 24, my lord. is the event.
Not January.
Can I just show my lords the IA filed by me, because these are documents produced by them in the Supreme Court. The IA number 2, because none of that is produced. My lords may just see the IA number 2, page 115.
For what purpose?
To show the school. My learned friend says that from 1 month they are in school. In fact, they are not, my submission is, their own documents, they have shown a fee document which says that the fee is for the academic year of the next year, 3rd standard and 2nd standard. My lords, the new academic year is not started. My academic year is continuing, even though in Goa, maybe the academic year, their start date may be different. They have, in fact, initiated proceedings in Goa.
What is the standard of that school in Goa?
This is one of the best schools in Goa, and they have been going to the school from past 4 weeks. I can produce
The fees, I don't want to go on the fees. My fees were, I'm sorry.
Permits us to.
Sorry, apologies, madam.
I can
Apologies.
produce the attendance record.
Huh?
I can produce the attendance register.
How long they studied in Bangalore earlier?
My lord, it's 2 years from past.
2 years.
Yes,
they have studied.
2021. They were admitted in Bangalore International.
What your client is doing in Goa now?
Because earlier she was prevented from working. So she used to bake, and she has done a lot of cookery classes and everything. She used to bake and earn her this thing and contribute also to the family. The same thing she's been doing there. And they come predominantly.
In Bangalore also cooking classes a lot taken
Yes, that same thing she's continuing
in Goa.
Goa.
It's not an employment. It's
No,
an
she's-
avocation.
Correct, yes.
Okay,
They
that can be,
basically come from
no,
the-
we are just exploring all possibilities, just the things which you are doing can be done in Bangalore also. Just we are asking.
I understand. In fact, no. I'm sorry. The
Yeah.
children were born in Goa, admitted to a school in Goa before they came here. And the information that is provided is the respondents, that is in my petition. The father's parents still live in Goa. And petitioner's parents also, that is in my petition. The girls and the father,
Yeah.
yes, the parents still live in.
It's all right. But for 2 years, children were in Bangalore only.
They're in back, yes,
And it's all after 26th November,
yes,
these things happen.
yes. They have been admitted to the next standard already, and they're going.
To ensure that
No year is
that
lost.
your case becomes stronger by taking longer period of academic admissions.
She didn't want them to
You
miss
would have
out
taken
on.
it for one, generally, perhaps most of the children, they are, the members of the bar will be having for 1 year admission, generally that is done. So we want to know, we have to derive as to why all this is done by employing our common sense experience.
this thing, my lords, there, the academic year starts in March. Here it ends in, I think, May.
March.
No, May.
May.
It ends in April or May, it ends here. There it starts in March, so that is how she could get them admitted and they have already started.
When father got the admission in July 2023, when everything was smooth, and with effect from which date children were going to Bangalore school?
Date
I have it, my lords. The, because I have produced the school admission, it is, my lords, from July. The academic year started in
Bangalore schools, my lord, normally. the
July
International
23.
school starts in the month of July.
Yes.
The academic year begins July and they end by end of February or March. Then they
No,
gave a 2 or 3 month
No,
break.
this
if they have
ends
kids.
in first
March.
week of, end of May. I'm sorry, that is a wrong submission. The father knows the children's school dates. They started in July, it's going to end in May. And in fact, I think it's, this is a different board. This is an international board. Whatever admission they have got in Goa, which has not even started, is a different board. It's a local board. And from the last 2 years, from the start of the 23 academic year, they were in Goa. I mean, in Bangalore, studying.
You would prefer to meet and mingle in these holidays along with the children?
Yes, my lord, can we meet? There's no difficulty. They can meet, son. Certainly they can meet.
My lords, the children still have school. Children still have school here. School here,
Friday, Saturday, Sunday, consecutively 3 holidays.
let her bring the children.
Friday is celebrated
Let
more
her bring the
pompously in
children,
Goa
yes.
than in other states.
Let her bring the children here.
Then we would like to see the children
Please, ma'am.
on Monday.
Please.
Monday.
So Monday you might have to.
But let them come over the long weekend so that the father can have the children. Let them come on Friday.
That is what we are trying to
Exactly.
suggest.
So Friday, Saturday, Sunday, that benefit is given.
That is what we are trying to.
Grateful, my lord.
suggest them.
Grateful.
My lords.
Friday, Saturday, Sunday, like my lord has now said.
Please.
Friday, Saturday, Sunday, 3 consecutive holidays. Let children come back to Bangalore. Let children spend time with the father. No allegation against the father at all. Purely except this one mega incident, if at all it has happened, we do not know.
There's an affidavit filed by the gentleman, my lord.
Which who will say that I'm only just I'm saying this.
No, but some background is explained also.
These things happen always. We understand that also, but we cannot go by just by the affidavit of that gentleman himself. He will say that nothing has happened. Maybe nothing has happened also, we do not know. We have to process everything in the light of the contemplation and other things. And the papers are also bulky. No, absolutely no allegation against the father. Not even one single allegation. All this happened only post 26 November 2023. And children were also here only. But it's not that we are saying anything else. For 3 consecutive days, children can be with the father, and father's parents are also here only, we are said. And if, will you permit the wife also to reside of 3 days in the same house?
Yes.
With all the honor,
I'll just take instructions.
security,
I'll-
safety,
I'll
with
take
respect.
instructions.
But we'll ask her also
Just
if
one
she's
second.
ready. And willing. Yes, we announced to come.
One minute, we'll ask him. We'll ask him, just wait.
Full security, safety,
And I'll just,
honor.
I'll check, because let it not be,
Yes.
If her mother accompanies her, if it's okay, my lord, she would like to feel comfortable with
That's all.
close family. But that's
Whether your client has any objection to go and stay with the, in the house where everything will be assured by them, so that you can be around with the children only. Or in the alternative, you can stay back and they will make arrangement for your stay, maybe in a 3-star hotel.
I shall accept.
And you can have a interaction, intermittent interaction with the children if she is so much, because there is nothing like that. The whole case, this only reminds me of what DVG said, Badukella Bedekata appears to be that way. Anyway, this has
Yes,
happened
absolutely.
that way. But some certain things happen in life. They happen in life that's how.
No, no, one second. May I just make a submission on that point? He is not comfortable to have her in the house, but what he submits is that either she can stay, there are places in that same apartment layout or in another place. And if she cannot stay, he will make an accommodation arrangement for her. If she's having any difficulty, he can definitely make some nearby accommodation
Only
arrangement.
the Friday, Saturday, my lord
Yes.
has said.
Ultimately,
Friday,
for 3
Saturday,
days, she should
Sunday.
have a place to stay.
One day, we, my lord and myself will be, perhaps, will be able to spend some time with the children so that we can ascertain
Yes.
their wishes also.
Yes.
This one.
Because
At
there have
the
been
same
other.
time,
Yes.
At the same time, this is, kindly consider this aspect also. That sometimes, which Shakespeare said, there is a tide in the affairs of men, which taken at the flood leads on to the fortune. There is a tide, and Byron said, there is a tide in the affairs of women, which you taken at the flood leads on to a place where only God knows where. In between these two stanzas, sometimes these things happen. It's not that we are saying anything in justification of allegation. We do not know. It's only allegation. We have not formed any opinion. And the kshama is a great virtue. In fact, just when saying,
Yes,
don't
yes.
respond.
No.
You are not supposed to respond.
Sorry, my lord.
Yes, you are a most matured lawyer, very respectable member of the bar. If the two sides sitting together, sometimes bad events happen in life, even when we do not want. We are driven that way. It happens. You have seen in Mahabharata that Duryodhana says to Krishna. Krishna asked him, "Why do you do all these things?" He says to Lord Krishna, he answers to Lord Krishna, "Janati dharmam nakame pravruttyaha, janati adharmam nakame nivruttyaha." I know what is the right path, but I am not able to tread on that. I know the path which I am treading on is a bad path, but I am not in a position to quit. Such compulsions do occur in man's life. Human's life.
Yes.
Therefore, consider whether you can sit together. Dear, these things happen, all right. Forget everything. And forgetful is also a great thing. If you can sit, because there are children.
Yes.
Because there are children. The network of relationship, which cannot be, it's a biological relationship.
Of course.
Cannot be easily disrupted. Whether you can sit together, maybe under the shadow of some great Swamiji, or both are Sikhs, it appears Sikhs. Is it not?
She is Christian.
She is
Christian.
She's a Christian. Then it is still better. It may be still better. They can sit together under the shadow of some good tree. Lord Buddha said, and you can work out. You can sit and talk. Two things. Whether our memory should be erased, if at all it has happened. Number two, if it cannot be, what alternate things can be done for the
For the children.
upbringing of the children?
For the children.
Sit together.
Yes.
Nations which have shed the blood paths have taken place. They sat together and worked out some peaceable solutions. Try that. Not necessarily joining together,
Certainly.
but other alternatives also, where you can have interaction. Only when our interaction fails, the skirmishes, disputes, arguments begin. Consider this also.
Lordship, may I make a submission, Lordship? With due respect, with ma'am's permission.
No.
Yes. Lordship, I was the advocate in the Supreme Court in this matter. Lordship, there's certain, the reason what Lordship is saying that forgiveness, absolutely, we wanted to settle this matter absolutely out and out because it's for the kids, it's for the best interest of the children. Lordship, the reason why we don't want the wife at this stage to come to the house, why the client doesn't want it, is because after, in the month of January, he has come across several objectionable matters with respect to his wife, in which she, I don't want to say it in open court, Lordship, those chats are also part of the record of the apex court.
Anyway, I think
So,
many
which
other
is why-
issues came out.
Keeping all that,
Yes.
Yes.
Now,
keeping
my
all
lords,
that.
let-
Just try.
Yes.
Three days,
Yes.
let the children come back, my lord.
Back,
Well,
and on
expressed.
Monday, we can meet with my lords.
Not only one thought occurred to me, my lord. Easter is the,
She's just staying in Goa.
my lord, she lives in Goa, my lord, with
No,
her.
if she comes to Bangalore.
If she
Lord
comes,
is
my lord,
asking.
she'll have to either stay with.
They said they will arrange for
She'll
her.
arrange
stay.
accommodation.
Only one doubt I had, my lord, Easter,
My lords, there is place in the house, but after all that has happened, my lord, there is great discomfort. He'll make arrangements.
no, 29th is Good Friday, my lord. Easter is the biggest and the holiest festival for Christians to celebrate. So I'm not very sure, my lord, whether she'll be able to leave her parents and come on that day.
He can go
So,
and bring the children.
though I see, my lord,
Saturday.
3 days, huh?
Saturday, Sunday.
Lord,
Yeah.
Sorry, 29th is a Good Friday, which is a day of abstinence and all of the pleasures.
Yeah,
of that.
fasting and
And then
other-
it is East, I think, Holy Saturday and Easter Sunday. is
They can
what-
celebrate it here, my
There
lords.
is
What
It was
is the
holy yesterday, I
difficulty?
couldn't meet my children on holy.
They can celebrate it here. Children are there.
25th
What
was
is the
holy, I
difficulty?
couldn't meet my children on holy, Lordship.
No, it cannot be this. They can
Just a small accommodation
come
if
here. I'm
possible.
sorry, all. no.
That is all.
Yeah?
Just a small accommodation if possible, my lords,
They won't
that's all.
be-
Because it just
It
occurred
is
to
in-
us that
Good Friday is when?
29th.
29.
Yes.
And Monday
That
he'll
day
be
is a
back
day,
at
my
work.
lord, when they have fasting and all that. The following
Good
day is
here.
also they continue,
Holy
they
Saturday.
conclude on that day, Holy Saturday.
And then,
Hmm.
yes, ma'am.
Following day, what was, if that is so, well, come to Bangalore only.
Come and do
Yes.
it here.
Yes.
Do it in Bangalore only.
Yes. All
Instead,
along.
what we were thinking was, as my lord suggested, so that, mingling, that also.
Very well,
Explore
maybe
that
Easter,
also.
my lord, is auspicious for them. Let them try.
The Friday, Good Friday is a good
Yes,
thing.
is a good,
Let
hopefully
good
it
things
will
begin
work.
with that.
Something may come out, my lords.
For you also.
Yes, certainly. Something may, hopefully something good may
Yes.
work out. Certainly, my lords.
Please.
Planning to come.
Yeah, if your
Still
lordship,
arrange
my
it.
lord, in the
Whatever
light of
your
the
lordship
observations from the honorable court, my lord, will advise her to come with the children
On all 3 days.
on, yes,
Yes,
either
all 3 days.
29th or 30th, my lord, in case it's
No,
not
my lords,
possible
all
for her at
3
all on
days.
29th.
My children should stay with her father. And
Yes.
she should be. And she should not. be meeting the children.
29th, she will be able to.
Yes,
come with
in
the
case, my
children.
lord, it's impossible because of this feast there, she'll come on 30th.
30th.
We'll advise her
Let
to
me
come on
get the 3
29th.
days. Let me get the 3 days. Again, on Monday, it is a working day. Let me get 3 days. Let the children be in my house. I'll make arrangements for her. For 3 days, let the children stay with me and my
Yes.
parents. And then on Monday, at least let me get 3 days, full days. My lords, my lords,
Willing to celebrate.
my lords
Lordship-
my lords' orders ultimately are binding on all of us. My lords, I leave it to my
I
lords.
think we
It's
can't
also
compel-
very
Lordship-
fairly they agreed to our
But we
proposal.
compel, we can compel, but we can't.
No, ultimately we leave it to my lords. Let me at least get that time is my only concern. Nothing, no other
Lordship,
concern.
25th, he was standing in this court on holy. It's not, he wanted to celebrate holy with his children.
You can start from Goa on the Good Friday itself.
Yes,
Evening.
Come
Yes.
down in the night.
Night.
yes.
Lord, we don't have the benefit of instructions at this moment. So what is occurring to both of us, my lord, I'm placing. Tomorrow they should not file one more contempt to say you are supposed to come on 29th, you did not come, you came on 30th. That's all I'm placing, my lord. It's our endeavor to tell her, my lord, to somehow manage to come. That's what my endeavor is. But don't bind me down in that sense is all that I'm saying, my lord. I will certainly advise her, my lord. I will personally advise her.
My lords may say 29th evening at least, so
Yes,
that.
when I mean.
At 2:30, seek instructions and come back.
Please,
All right.
please.
And you will be bearing the traveling expenses and expenses of the stay also.
I'll
Because
get
you want
instructions.
children to
Yes,
be
I'll
with
get
you.
instructions.
Just
I'll-
ask them whether
I'll,
they
I'll
are,
ask them that one.
ask them. It should be in a good
Yes, sir, yes,
two-star
yes.
hotel.
Yes.
He'll bear the respondent
Tickets
and the
also,
children.
tickets
Yes, yes,
also you
that
have to buy.
Yes. No, he wants.
At 2:30, please come and tell us.
No, he wants instructions. Grateful.
Do not mistake the quote which I said. It is from Mankutimmana Kagga, from DVG. Okay, I have not said it. I have only reproduced what the great DVG had said.
Say number 3.
Yes,
Contempt
Madam
matters.
Lord,
Zulfikar.
complied the order. DC has passed an order.
Yeah, it's passed an order, it seems.
907 Gunta land.
It's been granted.
07 Gunta.
Say number 3.
Yes, Lord. In this matter, I am filing a memo along with the order passed by the Deputy Commissioner.
I've just received the copy. If you may permit me to just run through
Direction
the.
was to consider representation.
Yes, yes.
Yes. Recommendation. Consider.
Yes. It's
Considered and rejected or granted?
Granted. Lord.
granted.
Granted. It is granted.
Is it okay?
Earlier, it was allotted to the traffic police station. 8.8 Gunta was allotted to the police station. Out of it, Lord, 1.08 Gunta has been denotified, de-reserved for the purpose of road.
No, to whom?
My apologies, Lord, it is in Kannada.
1.8 Guntas is for public purpose. Not, it is not granted to us. Order is for grant to us, but it said that it's for public purpose.
Stating in the earlier that revised order in the 16/3/24. Submitted. It has been passed by the Deputy Commissioner Vengal.
We don't have a
Vengal. 0-1 0-01.08 meters of land.
Please, Your Lordship. If I'm just going through the specific wording of the order. The directions were to grant a certain small portion to the complainant. But here the reading, it is so that it says it's a general order, says it's for public purpose. So to that extent, again, we are left in the lurch.
Page number 3, para 2, may I read it's in
Because
Kannada.
I've been served only now, so I'm also just going through it now.
ಸಾರ್ವಜನಿಕ ರಸ್ತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ.
We can quote on this.
But there is no comments also.
We ordered it Very well. 16,324.
Same land, item
Produced. Now contains the following recitals. Ask will be all.
Yes. Grievance is also addressed.
Shows that the grievance is taken care of.
If anything more remains, then you are right.
By a force of-
Objection. So with liberty that if there is anything left, I may come back to your lordship.
Before the contempt of the clause. Before nothing survives in the contempt of things, they are closed. I will verify that it is something given with regard to me. Is taken an order passed. Instituting independent justice. Or court, in accordance with law. In respect of which this court does not express any opinion.
Objection.
December 4, Mr. Chandrakant Argole.
My lord, the direction was, my lord, to hold elections, my lord, elections that have not been held. Page 21, my lord, is the order.
Hope ready to say.
In that way, the matter writ petition stand disposed of while directing the third respondent.
You are appearing for the respondent. Compliance report is filed.
No, first time it's coming.
Or learned is written.
I accept notice for R2.
Government figures.
December 5, Mr. N. Suresh.
Counsel for complainant, my lord. Actually, this learned single judge of this honorable court in WP number 25568. Much.
6. Number 6, Mr. Subramania Bhatt, yeah.
I appear for the complainant, my lord. I appear for the complainant, my lord. Operative
Decided
court
or not represented.
Not yet decided.
Not at this.
decided. my lord.
I accept for R2.
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 Great.
Accepted by government.
Number 7, Mr. Badrinath R.
I pay for the complaint.
There is
a delay in
no,
filing the complaint where I could not, hard copy was not communicated with the advocate representing the
But
complaint has been expired.
the order was 2020.
there's no contempt as such.
Annexure page number 17.
Where is the direct mandate?
Page number 21.
Read.
The writ petition as such is disposed of with the observation that the state government may be provided to funds to the construction of the hostel of the respondent of five. Who
May
shall
provide funds.
Providing of the funds to the respondent of five.
How can we read this as a mandate at all? In a given circumstance, this court has said that.
After 1 year and there is no effectivity. So forget about the. Writ petition was disposed. Vote 6 on page 10. On their reading of. The government will provide funds for construction of the hostel. Court does not find any mandate. In direction. It could be implemented. By invoking the contempt. Since there is no direction to be effectively contained in the order of invocation of contempt by the complainant. Discuss. No case of contempt. Accordingly dismissed.
This is semi-8.
For the
Yes,
complainant in
second
this
order.
case, my lord. This honorable court, single bench had directed the accused to consider my application and pass orders within 8 weeks. The 8 weeks period is over. It's been 3
What is
months
it?
after that, my lord.
To
For
consider.
regularization, my application for regularization had to be considered, my lord.
They have not done that.
They have not done it, my lord.
Notice third week of the reopening. Let it be in the beginning from 10th June, 10th June.
10-6. Still number 9. Vijay Kumar.
Hearing for complaint.
Same,
Same.
10th June, notice.
For R5.
R5 government. AG.
R5.
Still number 10.
For the complainant, your lordship.
Vinita,
In 10
please.
only.
10 R5. Notice.
Please.
Still number 11. Ali Shantappa.
That the complainant filed this complaint, more that, and that under the contempt of proceedings, more that. That complainant is an plaintiff before the trial court, more that.
That order is in RA.
RA is there, more that. Before that, more that, he filed a suit for declaration, possession and permanent injunction, more that. In that OS, more that, your lordship may kindly see that Annex A is the absolute order regarding the maintain the status quo order, more that. Page 25, your lordship may kindly see. Page 25, more that.
Page 25 is the order under contempt.
No, more that.
Page the
Then
order.
next, more that, subsequently my.
24 order by the learned senior civil judge.
That subsequently my suit came to be dismissed. I have filed the regular appeal, more that. That Annex C is the order sheet of the regular appeal, more that, your lordship may kindly see. Page 54, more that. In view of the IA number 1, the delay is condoned, keeping its merits at the same till next date of hearing. The operation judgment and decree date is 27 to 2023 in OS number 112 2014 is by stayed, more that. Now what happened, more that, this accused is on depend number 4, respond number 4 before the.
Because of division bench judgment.
What happened, more that, insofar as the interim order is concerned, more that I am relying on the judgment of apex court, more that. That page, your lordship may kindly see. I was relying on the Annex J is the judgment, more that. Recently, that apex court. So far as the status quo order is there, more that. Relevant para number 40, that is 11, more that, 11 on that, more that. In this matter, more that, what happened, the learned single judge has ordered to vacate the interim order of stay, given direction, more that, against which a special SLP was filed before the apex court, more that. In the apex court, more that, held that in the contempt petition, no order to vacate the interim order, if any, to proceed with the matter in the contempt of court act as per the section 11 and 12, more that. So remitted back to the learned single judge to proceed with the contempt petition on it.
Heard learned advocate, Mr. Ali Shantappa Basappa for the complainant. In the proceedings of regular appeal number 3 of 20.
And another one more judgment, that apex court, that in so far as the, even though undertaking by the council is also amount to contempt of
It's a
court.
different thing.
So
In the proceedings of regular appeal number,
how the deal with that section
Not
11 and 12? Kindly see, now.
we are not entertaining the.
We have considered similar judgments in that lead judgment. In terms of that, we have been disposing.
14th of March,
But
one more. Your lordship may kindly come to para 41 of the judgment, mother. Para 41, mother. Any interpretation with the, may I read, mother? Para 41, mother. 41 onwards, mother. which is an affront to the majesty of law, and conduct of the interference is punishable as a contempt of court. Public interest demand that there should be no interference with the judicial process. And then you will also may kindly see para 43 malda. The following conditions must be satisfied before a person can be held to be committed civil contempt. One is malda, there must be a judgment, decree, direction, order, writ or other process of the court. And second one is malda, there must be a disobedience to such a judgment, decree, direction, order, writ or other process of the court. Third one is malda, such disobedience of the judgment, decree, direction, order, writ or other process of the court must be willful. This is that what the insofar as the contempt petition is concerned, that there is a judgment and decree and the order, direction, writ or other process. That as per the section 2B, your lordship may kindly see 2B of the Contempt of Court Act, your lordship may kindly see that. 2B, Malad. 2B. The provision to section 2 of the Contempt of Court Act, Malad. 2B, Malad.
What happened to that RA?
That I have filed the IA 39(1) and 2 Malad in the regular appeal, Malad. That was.
Appeal is still pending.
Appeal is pending, Malad. Appeal is pending. Stay order has been granted to the dismissal of the judgment and decree, Malad. So automatically that my injunction order came into force, Malad. And 2B, your lordship may kindly, civil contempt means willful disobedience to the any judgment, decree, direction, order. Your lordship may kindly see order, it includes the interim order, Malad, also Malad. And writ or other process of the court or willful breach of an undertaking given to the court, Malad.
Proceedings dropped in view of the division bench judgment, so it's referred to the Supreme Court judgment which has cited.
And one more thing, Malad, Nano.
Result to the, no, we can't.
That in the apex
is result to the complainant to take up appropriate proceedings in the court in which the RA is still pending.
And may I make one submission of that? May I make one submission of that?
All contentions are kept.
May I make one submission of that? Kind. That I filed the application under 39(1) and 2 in the regular appeal, Malad. That was posted for the objection to that application, Malad. So you will also may kindly direct the trial court to dispose of the IA 39(1) and 2 early disposal, Malad. That to decide the application, Malad. Because
it is open to the complainant to seek at the hands of the court below as to early disposal of his application filed under Order 39 Rules 1 and 2 of CPC in accordance with.
This PL matter, seal number 12, Mr. J.R. Mohan.
Keep on standing.
Hearing for the state, Mela.
Mela, this writ petition is for a direction to the respondents to consider my representation for formation of connectivity road between 3 villages. Mela, the village is called Bhavani Bijalgaon, Torana, and Mudhol. These 3 villages are situated at a distance of about 5 kilometers apart, coming within Kamalanagar Taluk, Bidar district. Mela, there is no connectivity road between these villages, Mela. Because of
what
this.
should these are matters which are left to the wisdom of the executive.
Yes,
We have a
yes,
separation,
Mela. Yes,
doctrine
Mela.
of separation of powers.
Yes.
Can the court say? Apex court has said all right, but can the high court say that you construct a bridge, you construct a flyover?
No, Mela. I agree.
We have already held that one.
I agree, Mela. I agree. Just a direction mechanism to consider my representation, that's all.
No, that is not. You can go, nobody prevents, but we will not give any.
Because, my lord, because of this, since there is no connectivity road, the people have been facing very much hardship, even to reach their own lands, my lord.
These
Even
things
to-
you should bring to your representatives, to the government. They will take that.
I have brought it to notice of the government also, my lord, but they have not considered my representation. The lordship may kindly see the annexure B and C, my lord. These are the representations made by me to consider to form a road.
where is the duty to consider
Yes,
request for
it is
formation
not
of the
there.
road,
Yes.
reservoir? That duty you have to show. If there is a corresponding duty, we will issue that one. Merely because you have sent representation, we cannot say, you will send a representation saying that the particular public building should be pulled down. Can we direct, where is your
No,
right
no,
to make a
No, it is
representation?
for the larger interest of the general public, my lord.
This petition filed in PI jurisdiction has the following scripted prayer character. First, having heard the learned counsel for the petitioners and having perused the petition papers, we are afraid that no relief of the kind can be granted in as much as our system operates on the broader principle of separation of powers. First, the prayer for a direction to the respondents to construct roads, etc. Certainly does not fall within the domain of the judicial institution as held by this court in the case of Hubli judgment, Hubli flyover judgment. So next, in view of the above, the petition is a petition being unworthy of merits is rejected in limine.
6/13, the Pradeep HS.
I am for petition. This is a petition for respond number 11, encroachment of the Raja Kaluve and stormwater drive. The encroachment of the Raja Kaluve by the respond number 11 by constructing the huge construction, that is apartment on the Schedule A and B property ownership. The respondent number 5 has issued the notice and suspended their plan, sanction plan, that is wide resolution, which is internal page number 127-8.
Notice. Notice returnable on.
My lord, I take notice for respondents 1 to 4.
What is constructed?
Any interim order not to sell the
notice of
5th June. Learned edition. Accept. So and so.
Chaudhary Pollution Control Board. Copy, sir.
R8. December 14th, to Bhargav Dev.
My lord, this is another case of encroachment of the Raj Kaluve as well as a road. There is a report, there are multiple reports, one by the revenue inspector as well as by the Tahsildar to the deputy commissioner. But no action from the deputy commissioner till date. Produced photographs, my lord, the construction is going to be complete. I've sought for an interim stay. Because they'll complete the construction. Then all third-party rights will be created and thereafter that is the fear, but not
immediately on reopen, 25th of April, 29th of May.
1, 2, 3, 4.
Notice.
My lord, I take notice.
Notice to others.
1, 2, 3, 4.
4. Green bench matters, number 15, Mr. Ramana, MVB.
The petitioner waits time to be granted. Supreme Court direction.
On submission, Lord, number 15. Clear round of petition, Lord, I have filed Wakalat for respondent number 5. My name is not shown, Lord. Now.
Lord, serial number, so far serial number 15 is concerned. Lord, it is in the nature of public interest. Lord, he is seeking to cancel the consent granted to somebody.
It's not a party.
He has to
Lord.
satisfy his locus.
He's not an aggrieved party, my Lord. In fact, the petitioner is not an aggrieved party.
Only and on that basis, this Honorable High Court had disposed of the writ petition, Your Lordship, to avail the right remedy. They
Which is
are-
That this is challengeable under 31 P.
Even
This
if
is
it petition
25,
appealable,
section
Lord,
25 consent.
Please.
25 consent.
So far as appeal is concerned, Lord, appellate authority is not sitting. Therefore, he can maintain the writ petition.
But what is his, he's not an aggrieved party, is your submission.
That is my submission.
It is not an PAL, my Lord. It is a private.
It's a private petition.
The petitioner is aggrieved by consent for establishment granted to respondent number 5, your lordship. The order sought is to cancel the consent for establishment granted by the board to respondent number 5.
How you are an aggrieved party?
Weeks time we were granted, my lordship. Senior is not.
You are a stranger. Next witness.
My name may kindly be shown for respondent number 5, my lord.
You appear for respondent number
Please,
5?
Please, I have appeared in the earlier.
Who is 5? Pollution.
Please, this private party, my lord, respondent number 5. Please.
So, madam, you appear for pollution.
Yes, your
Pollution
lordship.
Control Board.
What is your name?
My name is Prishka Vaishnav. I appear for A. Mahesh
Yeah,
Chaudhary.
Chaudhary.
Yes, sir.
Next witness.
Please.
No further time.
Please.
No, 31 and 31 identical to this, your lordship.
Identical.
Yes, identical in the sense, Lord, your lordships may recall there were two orders of the benches. Lord.
This is serial
One was
number
on
15,
alternate
sir.
remedy.
Serial number 15.
This is 15.
15, yeah, identical to that is item 31, Lord.
17 is serial number where demand notices have been.
Oh, I'm sorry.
Different.
This is different.
Reading up. Number 16.
Petitioner, the petitioner has challenged the annexure, yes, my lord.
Shastri Sahib.
Serial number 15, 4th April. Serial number 16.
I'm for petitioner. The petitioner has challenged.
Fourth is which which 15. Sixteenth is what?
Petitioner challenged the annexure, yes, my lord, at page 95.
Deemed forest.
Yes, my lord, deemed forest.
Lord, it is an order passed by the Lord competent authority.
Apex court affidavit filed before the apex court.
Same affidavit.
Yes.
No, that's not.
This is a rejection of the quarry lease application.
Quarry lease.
On the ground that it is a forest, deemed
Forest,
forest.
deemed
land.
forest.
No, my lord wants to know whether this village was enlisted in the affidavit which was filed by the government of Karnataka, state of Karnataka before the Supreme Court.
Yes.
In Godavarman.
Yes, yes, yes.
So we are still searching what is being.
Yes, the other day we, something we found. Two judgments referred to, apex court judgments. referred to deemed forest lands.
Lord, and one more aspect is, Lord, it is a rejection of lease based on that ground. And remedy of revision is
53.
53 is also available to.
Adon ide, but
In one of the matter,
this court has passed that.
So
That other day, Mr. Valla argued that matter. No?
Yes.
We can call this matter along with that because identical issue is involved.
Please.
tomorrow it is coming,
2nd April.
probably tomorrow. Probably tomorrow.
We can call this matter along.
2nd April.
2nd April.
Second.
We'll say that this will be called along with that.
Please.
whichever day.
To be listed on second.
AGA for response.
Please, ma'am. Much.
Your lordship, in serial number 18, your lordship, 17, 31 and 71 are pertaining to the environmental compensation, your lordship.
Number 17.
Only 70.
17, serial number 31 and serial number 71 are on the same point where environmental compensation.
Which you have
Appear
mentioned.
in 31.
It may be had at 2:30, your lordship. Senior will address.
And that
after.
group is kept. Fourth.
the group of review petitions and this petitions have to be tagged along. And it may be had at 2:30 today, Your Lordship, we'll address arguments.
But other matters are not posted today.
It is
They are
serial
also
number
posted.
71, Your Lordship.
In 71, I appear for the.
In 71.
So RP's minutes.
Honorable
And there are a
Supreme Court-
couple of writ petitions also in 71 minutes of the same demand notice.
We'll take up all the matters on 15th.
15th of April.
Please,
15th.
interim orders may have to be kindly continued.
Milords, meanwhile, let them not precipitate.
We have not precipitated it yet, Your Lordship.
There have
We'll-
been interim orders in all the connected other matters, Milords, and even in RP's. minutes.
In these matters, no interim order
No
is yet to be granted.
In my case, it's interim order is there.
Already there.
31 and 31.1 interim orders are operating till today.
We, given an undertaking that we will not take any precipitative action against the petitioners, Your Lordship. We have informed the board as well.
You have informed the,
Board that no precipitative action may be taken against the petitioners in these.
no, that
matters.
is in.
No, the
not
other,
announced,
in
right?
all the
In other
petitions.
matters also.
Yes, yes. Sir.
That assurance. is
Please.
sufficient.
My lords even was pleased in RP Milords to raise a point to urge by us that whether board has got a jurisdiction to issue such a. That
Along with all these.
much.
Lord, on that natural justice point, Honorable Supreme Court has now, my Lord, pointed out that since this Honorable Court had not decided on merits in that case, on alternate remedy, the Lordships have directed it should be heard on merits also.
Okay, there is a
So,
direction.
yes, my Lord. There was two viewpoints, my Lord. In one case, alternate remedy, my Lord, the petitions were dismissed, saying you file appeal. And in another case, my Lord, the Honorable Division Bench had gone into the merits and recorded a finding against the board. So they were citing that earlier case to say that this Honorable Court should follow the same thing. Now, Honorable Supreme Court has made it clear, my Lord, that particular case where it was dismissed on alternate remedy, there's the direction to hear it on merits also. So your Lordships will have to kindly consider all of them together.
So in other words, alternative remedy will not bar the matter
Entertainment.
being entertained on merits.
Please.
That's your.
Please.
The other day I said, therefore we said there are three patterns of.
Yeah, I've
cases.
kept all the judgments also
Correct.
ready. Clear.
Interim orders, Milords.
Yes, whatever interim order is there, that continue. Otherwise also there is assurance that they will not precipitate the matter.
Please.
Item 71 also.
They are already notice for the matter. 17, 18. Or notices.
17th and 18th notice, renewal on 7th. We will waive,
Mahesh Chaudhary.
we'll waive for the board,
Yes, Your Lordship. Mahesh
except for
Chaudhary.
the board.
Vice Chair.
And Mr. Mahendra will accept for
State.
state.
State and authorities.
Yes.
Yes.
This is for 19, RG Kolle.
Kindly
My lord,
let me open.
I appear for serial number 18. Serial number 18 has no bearing with the previous case.
Serial number 18, Lord, is the next matter. It is not connected with all this. Here, the prayer is.
Connected matters list kodi mat bere other list ಹಾಕುವ. Only give that connected matters list.
18 ilva?
No.
18 is independent.
18 is independent.
Here for the petitioners, my lords. Petitioner is owner of survey number 227 and 229. Abutting this survey number, 225. On 10/9/2006, respondent number 1 allotted 8 acres of land in 225 to create a garbage disposal and waste plant. In 2014, the petitioner wrote a representation to respondent number 2 complaining that the waste disposal plant was not created, but instead the waste was being dumped on the road.
Because we have waste management model by the state. In terms of. Who appears for answering respondents?
Let's
Who should consider?
My lords, respondent number 2 has also intimated respondent number 3, that's the town panchayat.
Panchayat has to consider.
Yes, my lords, they have to create the waste, solid waste management plan.
Moodigere town.
Yaar appear.
Moodigere town.
Any panel council? Sorry, next. We can dispose of directing the Moodigere town panchayat to consider.
This town panchayat. Directing all the data. All the.
Moodigere panchayat.
This one. Is this PI? No.
No, man. It's my personal grievance because the land is abutting my land.
Hard learned advocate, Mr. Darshan L.
Yes, ma'am.
For the petitioner. You are a please.
A. Mahesh Chaudhary for respondent number 2, your lordship.
Learned advocate, Miss.
Krishika Vaishnav for A. Mahesh Chaudhary for respondent number 2, pollution control.
Respondent two.
Yes,
One
your
is,
lordship.
AGA is one.
Number 1 and number 2, in that order.
Yes.
For the respondents. The petitioner claims to be the owner of the land. Survey number 227 and 229, situated at Nandipura village, Moodigere Taluka. And further claims to be possession of the said property. It is the case of the paragraph. Petitioner that is number 1. Deputy Commissioner, Chikmagalur, allotted 8 acres of land in survey number 225 of the said village for disposal of garbage and waste management. This parcel of land so allotted is stated to situated about 1 kilometer from the coffee estate of the petitioner. The petitioner has made grievance by addressing email dated 15/9/14 to the Karnataka State Pollution Control Board, respondent to hearing about unscientific disposal of the waste and garbage in the village. It is stated that respondent 2 has issued direction to the Chief Officer Town Panchayat of Moodigere on 16/9/14 to take necessary and proper steps for the purpose of disposal of the waste and garbage in the said land. It is the grievance of the petitioner that the respondent number 3 has failed to adhere to the direction issued by respondent 2. It is on such premise of basic facts paragraph that the following prayer is made by the petitioner in this petition. Quote, directing, it is prayed by the petitioner to direct the respondent number 1, 2, and 3 to take proper and necessary steps in accordance with the Karnataka Municipalities Solid Waste Management Model Bylaws 2009 for processing the garbage and waste management within the area allotted as above. Full stop. Since the prayer is made only to direct the respondents to take proper steps, some of the same could be considered. Full stop. The primary grievance appears to be against this country for its inaction pursuant to the direction stated to have been received from respondent 2. Full stop. In that light, without entering into merits of the case and the controversy, the purpose will be served if the respondent 3 is directed to take necessary steps in accordance with the aforesaid model bylaws of 2019 regarding solid waste management and take appropriate decision within 1 month, within 8 weeks. in accordance with law. The petition is according. It goes without saying that all contentions of the parties are open to be raised in accordance with law.
Let him. That petitioner may be directed to produce this copy to the.
Registry will serve, you will serve. Registry is directed to forward the copy of this order to respondent 3.
Much obliged. Much obliged.
Number 19. Rajiv Pandit.
Please, my lords. I was granted a quarry license over an area of 4 acres comprising 2 different survey numbers, one at 49 and another on 55. And 49 survey number measuring 2 acres got converted by the orders of the learned deputy commissioner. Remaining 2 acres in survey number 55 was not got converted into non-agriculture. That's why a corriendum order was passed by the third respondent deputy director stating that till that remaining 2 acres land in survey number 55 is also got converted, you are prevented from operating that is. I abide by the said orders, and even for remaining 2 acres land also, NA order was obtained as per annexure E at page number 74, my lords. And way back on 15/12/2023, that order was delivered to the office of the third respondent.
These are section 95 orders.
No, 95/9 order, my lords. And
yes,
till now also, I am not permitted to operate that newly converted area. My only humble request is I may be allowed to operate in that area, modifying the corriendum order, my lords. Because
the corrigendum says?
So till I get an order.
Conversion order, you are not entitled.
Yes.
To. So the lease as such, the
Yes,
quarrying
it is
license as such remains intact.
Continue because
its effective date changes depending upon the orders of
no, my
conversion.
lord. Since it is operational, that also cannot be modified, because now that the authority says that Kannu Tappininda quarry lease was got executed for entire area of 4 acres. I am not going to impute anything whose Kannu Tappu, but anyway, my lords, the fact remains as it is. I had not, from the date of that corriendum order, I have totally stopped operating. And now, only after passing a correction order, I may be allowed to operate in that area.
When did you make a representation seeking permission of those people to resume quarrying operation?
Because on 15/12/2023.
Where is that?
So it is at page number 74. I have submitted the copy of the order passed by the learned deputy commissioner, my lords.
No. After this order is made, you are seeking mandamus.
Yes, my lord.
So mandamus, law of mandamus says there should be demand and refusal. When did you demand?
No, because the order itself says that at page number 56, my lords, last sentence, my lords, I may kindly be permitted to read, which is in Canaries. Manya Jilladhikaryamda Kolagata Gram survey number so and so 2 ಎಕರೆ ಪ್ರದೇಶ ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಪಡೆದು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸುವವರೆಗೂ ಗಣಿಗಾರಿಕೆಯನ್ನು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಸ್ಥಗಿತಗೊಳಿಸಲು ಸೂಚಿಸಿದೆ.
Correct.
After that, I have submitted the copy of the order of the deputy commissioner.
When?
On 15/12/2023. That's an acknowledgement is I have produced, my lords.
Only order you have produced?
Yes. They
did not give a letter. DC has passed the order, permit us to resume the.
So probably the client has not taken that step, my lords. So anyhow, learned government advocate is here. If he is kind enough to issue instructions to the concerned authority, that is fine. Or whichever my lords say, I will bow down, my lords.
Therefore, it was kept under.
Now it is and is converted.
Now converted.
Now it is converted.
We'll consider, my lord,
Consider
till
the-
within that time.
Our learned advocate, Mr. Mohan. What is your good name? Ravindra Gajanan Kale for the for the petitioner, and learned government advocate, Mr. Mahendra for the respondent, state of Karnataka and its authorities. What is made in this petition filed under Article 226 of the Constitution is to direct the third respondent, dash deputy director and competent authority, allowing the petitioner to resume the quarrying activities on the land at measuring total 4 acres in the survey number 49/1, 49/2 and 55 of Kolagatta village, Turuvikare Taluka, Tumkur district. It is stated that on the premise that the said patta of survey numbers has been converted into non-agriculture. It appears from the facts pleaded in the petition paragraph that the land survey numbers 49 and 40 9(2) was already converted into NA, and the quarry license was given for a period for 20 years, effective from 19/1/22. The corrigendum order came to be issued by the authorities on 16/9/22. Restricting the quarrying operation only in respect of two survey numbers, 49/1 and 49/2, excepting survey number 55, in respect of which also the license was earlier granted, on the ground that the said survey number 55 was not converted into non-agricultural purpose. It is the case of the petitioners that despite there being a deeming provision under section 95(9) of the Karnataka Land Revenue Act, the authorities acted to exclude the area from quarrying operations. Thereon, paragraph.
Not one submission, because the earlier order granting license to the total extent has been withdrawn.
Correct.
Withdrawn, and it is restricted only to the extent where the conversion order was granted. Now, it is for the authority to grant, they have to issue a fresh license to the remaining extent.
No,
Because
I beg your pardon.
I may permitted to
It is
read.
not withdrawn, only corrigendum issued to take out that 55. Survey
No,
number 55.
Not, in Kannada, it is clear, my lord, page number 55.
Page 55.
It says, last 3 lines of the order, Tiddupadi Guttige Kararu Adesha, may I read that? ಮಾತ್ರ ಕಲ್ಲು ಗಣಿಗಾರಿಕೆ ನಿರ್ವಹಿಸುವ ಪಟ್ಟು ಕಲ್ಲು ಗಣಿ ಗುತ್ತಿಗೆ ತಿದ್ದುಪಡಿ ಕರಾರು ಆದೇಶ ಜಾರಿ ಮಾಡಲಾಗಿದೆ. Has been
Not withdrawn.
ಹಿಂಪಡೆದು
ಹಿಂಪಡೆದು.
what is there, but they have reissued.
Not only that, ತಿದ್ದುಪಡಿ ಕರಾರು ಆದೇಶ, that is not corrected agreement has been issued. ಆದೇಶ ಜಾರಿ ಮಾಡಲಾಗಿದೆ. Therefore, in respect of the remaining portion, my lord, accepting this conversion, they have to issue.
So by corrigendum, you can conceal the entire coring area. Cancel the permission for entire area.
No, my lord. Only to the portion of.
That is what we did. Right? That is what.
Therefore, we expect representation. Small things. We, all these problems arise because of, will not say more than that.
I consider my lord.
One representation you should have given.
Arrest
We would
my
have,
lord, let
we would
him-
have known what is your grievance.
Let him.
All hidden, we assume that there is some hidden googly in this.
No, only, sorry,
is
my
that
lord.
then?
I may,
of
permitted, I
property
will,
of the-
I will add one word, my lords. Because of the official readiness, because of ensuing
I am sorry, my
parliamentary
lord.
elections.
Law requires conversion.
Having highlighted the aforesaid
Nothing
text,
the-
Malone the petitioner pointed out from the pleadings that now the survey number 55, the question has been converted into NA, non-agriculture, and an order dated, by order dated 12/12/2003, passed by the jurisdictional deputy commissioner. In full stop, the area which is now permitted to be converted into non-agriculture in the state survey number is to the extent of 2 acres. Full stop. In view of above, it was further submitted that the total area comprising of survey numbers 49-1, 49-2, and 55 of the Kolahatta village, where the coring operations are carried on by the petitioner, are already converted
Already converted.
into non-agriculture. Full stop. As the aforesaid facts are stated, comma, learned government advocate would submit that the competent authority of the respondent will examine the case of the petitioner for permitting the coring operation in the entire area as originally granted by verifying whether the NA conversion is permitted in respect of survey number 55 also. Full stop. While the court does not express any opinion on the final order which may be passed by the competent authority, comma, while processing the case of the petitioner, comma, the aforesaid facts and the orders, if passed regarding conversion, shall be taken into consideration by the competent authority.
So
With the
outer-
aforesaid observations, the petitions are
Time frame may kindly be, time frame to pass.
disposed of with further direction to the competent authority to decide to render a decision after the examine the case as above within a period of 6 weeks. 6 weeks?
6 weeks.
Please, my lords.
Applies.
Seal number 20.
And with the leave of the court, Madam, kindly pass over the matter, Madam.
Pass over.
Number 21.
For the appellant. The sale deed was executed by the Bangalore Development Authority.
Sale deed is posted by Learned Assembly. Sale deed is set aside.
No, it has not been set aside. Since there is a civil suit for declaration pending between the parties, the learned single judge said that.
Read up it. Yes, what is the order?
Lord, page 23 is the, page 22 is the impugned order. Lord, what had happened was the Bangalore Development Authority had executed a sale deed with respect to a land which was not existent. In fact, the Bangalore Development Authority, my lord, had given us an endorsement saying that apart from 1060 square yards for which a sale deed had already been executed, there is no other land that is available. Having given such an endorsement, my lord, the Bangalore Development Authority has executed a sale deed at Annexure A, which was impugned before the learned single judge. My lord, the learned single judge.
Your suit is still pending.
Suit
is for?
Yes, suit is for declaration.
That
Declaration of title with respect to the entire disputed land.
The rate petition, the prayer is to set as the sale deed. That is not permitted.
My lord, my lord, the entire controversy has arose because the Bangalore Development Authority has given two endorsements, two contradictory endorsements. One in my favor saying that there is no additional land that is.
That is probably based on the sale deed.
No, before execution of the sale deed, because one endorsement is given to me
which my lord will get it at annexure L, M and N. I had produced those documents before the
Correct,
learned
but,
single judge as well.
Whole matter is writ large in the suit.
My lord, the entire controversy in my respectful submission, my lord, could have been set to rest if only the Bangalore Development Authority had filed its statement before the learned single judge, my lord.
The single judge said you have filed the suit.
It's true, I have filed a suit. I had produced the suit, my lord. May I request, my lord, that the BDA makes it stand clear whether there is additional land or that there is no additional land, because both the sale deeds were executed by the Bangalore Development Authority. And they have given self-contradictory reports. One saying there is additional land and the other report saying that there is no additional land. So the entire controversy could be narrowed down if only the Bangalore Development Authority makes it stand very clear, my lord.
This writ appeal is directed against judgment and order dated. Say heard learned reviews one. This writ appeal is directed against judgment and order dated 27th March 23 of learned single judge, whereby the writ petition came to be dismissed for the prayers made therein by learned single judge, observing inter alia that when the petitioner has filed original suit number 691 of 12 against the respondent 325, seeking relief of declaration of title, the prayer regarding cancellation of sale deed executed amongst the parties, and respondent through and under which the respondents number 2 and 3 have been claiming their rights would also be subjected to prayer for cancellation in the same proceeding of suit. Paragraph. In the writ petition, what was prayed by the petitioner was to set aside the sale deed dated 28/12/12, which was executed by a second respondent in favor of one Srimati Parvati Pandit. Full stop. Respondent 3 and 4 have been claiming their rights under said Parvati Pandit and the said registered document executed in favor of said Pandit. Further prayer was made in respect of setting aside of khata conferred on respondent 3 and 4 on 26/2/14 in respect of the property in question. The property was the subject matter of transfer under the aforesaid registered sale deed. Full stop. At the outset, it has to be observed that the prayer for setting aside the sale deed could not have been considered could not have been granted could not have been prayed, much less granted in the writ proceedings. Full stop. Learned single judge has rightly rejected the petition. Full stop. This court entirely endorses the view of learned single judge that when the suit is pending, the parties have to work out their rights, including the cancellation of
Sale deed.
if so advised in the suit proceedings only. Full stop. The prayers in the writ petition were misconceived and have been rightly rejected by learned single judge. No case is made out to interfere in the appellate jurisdiction. The appeal is dismissed as meritless.
My lord, may I make one submission, my lord? My lord, the orders passed by this court should not preclude the Bangalore Development Authority from initiating action if at all it is found that the sale deed is executed with respect to a non.
It is outside the scope of the very original petition.
Seal number 22, Mr. Virendra R. Patil.
My lord, I appear for this state.
The 21. Yes, auction is over.
My lordship. In this case, appear for appellant in this case.
This is which number? 22.
State Government of Karnataka amended the PTCL Act and 27/7/2023. So impugned order passed on 28/7/2023 without consider the amendment by the learned single judge. So PTCL Act
Identical. This is not
That- no.
identical.
These proceedings, my lord, culminated before the PTCL Act
Before the
came
Amendment
into-
Act.
Came into force.
connected matter of some court granted this status quo. Same land in question.
Maybe, but these proceedings were concluded before the amendment.
After the amendment.
My lord, before the amendment, before the coming into force of the act itself, 1179.
Before the act itself, parent act itself. How that is maintained?
My lordship, in connected matter.
It's all right. These are all entry models, so you can't cite them as precedents. Now, this transaction happened anterior to the enactment of PTCL Act.
From the date of Sagoli Chiti. Sagoli Chiti issued in the year.
Sagoli Chit is consequential document. Grant followed by Sagoli Chit.
So as per
It
the
is
Sagoli
Manur
Chiti-
Matsap's judgment.
So act came into force on 1179.
79.
It was converted into industrial purpose on 2 years back, 7/10/77.
to conversion made by the purchaser, lordship, not by the grantee. 77 is
In
conversion.
any case, prior to coming into force, isn't it?
Yes, grant is prior to coming into force of the
So
act.
violation is there. Within a 15 years, land in question has been alienated. So in the year 1976, lordship, so land in question has been alienated. So 74 to 1970, Sagoli cheat has been issued. In the Sagoli cheat, condition also mentioned.
Grant is of which year?
My
Grant
lord, grant was made on 7/3/1964.
7/3,
My lord, initially it was on
1964, and
30
sale did happened on?
My lord, sale happened on 5/11/1976. My
That
lord,
is
the-
before the enactment.
Yes, yes.
another one thing, lordship. So fresh Sagoli cheat has been issued. 4
That
to
makes
1970, in the Sagoli cheat, condition also mentioned.
That's all right.
within a-
Sagoli chits are only consequential documents. They are not title deeds. The title deed is the
Another-
grant and the sale deeds, nothing beyond that.
Another one thing, my lordship. Land in question is pending before the Sambal court.
How that will be, how
Same
act
land in
itself is
question.
not applicable to you.
Same land in question.
We'll duplicate this order in those cases also.
Same land in question is pending before the Sambal court. Same land in question. Status quo has been granted by the Sambal court. I am also one of the respondent in this case.
Because on
1/1/1979.
we have taken consistent view of the court seals, the transactions that took place anterior to coming to force.
Sambal court granted a status quo order in same land in question. I am also one of the respondent.
This appeal is directed against the learned single judge's order dated so and so, whereby WP number so and so has, WP number so and so has been negatived. First, the reason assigned by the learned single judge is that the transaction of sale happened on 5/11/1976.
Yes.
And the PTCL Act came into force on 1/1/1979. And therefore, the benefit of the act cannot be tapped. First, this view is consistent with hundreds of judgments of this court. First, in view of the above, writ appeal being devoid of merits is liable to be and accordingly dismissed. AGA for officers. Registry to send a copy of this order to the private respondent.
Same land in question is status quo has been granted. my
The
lord.
contention of, the vehement contention of learned counsel for the appellant that in similar matters, even in respect of the very same land, some interim direction has been granted for maintaining status quo, does not come to his aid.
ಸ್ಟಾಪ್ ಮಾಡ್ಲಾ? ಮಾಡಿಲ್ಲ ಮಾಡ್ತೀನಿ. ಅಂದ್ ಲೀವ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ. ಇಲ್ಲ. ಹೌದಾ? ಆಫ್ ಮಾಡ್ಬಿಡಿ.
ಸರ್ ಯಾವ ಲಿಸ್ಟ್ ನಡೀತಾ ಇದೆ ಈಗ 36 39 ಸರ್?
ಹಾ ಇದು ಮಾಡಿ ಫೈಲಿಂಗ್ ಆಗ್ಬೇಕು. ಹಾ ಸ್ಟಿಚ್ ಮಾಡ್ಬಿಡಿ. Send it, no, call Shashi. Tell him to take it and go file it.
Lord, I've taken instructions, my lord. I have a twofold submission to make, my lord. This weekend, it appears it'll be difficult for her to come because they have, my lord, some two family gatherings also at that time. So I was thinking, my lord, to make use of this. If this weekend, my lord, the husband can go to Goa and have interaction and keep the kids for a few hours and let the ice be broken. Following weekend, she will come, my lord, and spend 2 days. That's what, my lord, is the suggestion that I'm respectfully making. Any day he can come, my lord, if weekend is convenient for him, Saturday, Sunday, Friday also.
And you will leave the children with him only?
Yes, my lord. Only night he would like to, my lord, take the children back to the house.
Why night? What is the allegation against the father?
No allegation, my lord. Only apprehension of the mother, that's all. No other allegation.
That's one single allegation is not there. Now also, you are saying that you are not coming to Bangalore. Very well. Then yeah, let him go to Goa, let him stay, let children stay with him.
No, in fact, he even said, if she wants to celebrate Easter there, she can drop the children here and go back. He will spend for her two-way airfare. Like she can leave the children here, she can go back. No, I'm just.
Some adjustment. We cannot do things with Portia's knife.
No problem. I'm just suggesting
some
that even if she has any difficulty, because even in the past weekend, overnight, he has spent.
To go to Goa to take them and come back.
Please, let him go to Goa, my lord.
And
let
bring
him
them.
spend time with the children on his own also.
No, no.
Bring them
He will
here.
bring the
Bring
children
them
to
here.
Bangalore.
Yes.
Because his parents are here.
Yes.
You can also accompany.
Yeah,
Yes,
if she wants,
we'll
let
bring
her
them.
accompany. And she can't hold children that way.
No, not
We'll
holding.
bring
Lord.
That appears to be
We'll
the
bring them
favor.
here.
I'm only suggesting, Lord, that let this weekend, let them meet, my lord, because there has been some.
We are also suggesting.
Therefore, you go.
You are ready to go to Goa and bring them back?
Yes, yes. We will go bring them
Lord,
back.
the
Otherwise,
mothers.
let her come.
They will come to take you.
Very well, my lord. She will come, my lord.
She will come.
Yes.
Then we pass. We cease the contempt application 214 with writ appeal number.
Not one other submission, my lord, is she is willing to stay in their house, my lord, with her mother. If they have no objection, they said that should be
No,
okay.
we'll make arrangements for, we will bear her ticket.
Ask them, ask them, ask
No.
them.
No, we've asked. He has some difficulty that she come to the house. He will make arrangements for her to stay. He will make arrangements for her to stay nearby, and he will cover her and the children's travel. Not in the house. He will arrange for her to stay.
The captioned contempt application. The captioned application under the Contempt of Courts Act 1971, as well as the writ appeal. Writ petition. Writ petition. Arise out of same order, judgment and order. Same judgment and order dated 6th February 2024. Passed by learned 5th Additional Principal Judge, Family Court, Bengaluru. In the application number, in the proceedings, in the application number 442 of 23, filed. By the petitioner husband under the Guardian and Wards Act. Full stop. Paragraph. While the husband. That's the petitioner in the contempt, the complainant in the contempt application. Seeks to enforce the directions contained in the order of the family court. Complaining breach thereof. On the other hand, the petitioner wife in the writ petition has called in question the said judgment and order for the grounds raised in the petition. The operative paragraph portion of the order of the family court and the directions contained therein are as under page 85 in the contempt proceedings. It is, after quoting entire, it is relevant to note that the application number 442 of 23 under the Guardians and Wards Act became subject matter of transfer petition for the Supreme Court by order dated 16/2/24. The Supreme Court by order dated 16/2/24 passed in transfer petition number 342 of 24. The Supreme Court stayed the proceedings of the said custody petition number 442 of 23. Thereafter, order dated 14/3/24 came to be passed by the Supreme Court. So the said order dated 14/3/24 reads as under and quote the entire order. It is in light of the aforesaid order and the clarification by the apex court that this court has proceeded to consider the contempt application as well as the writ petition. Since in both paragraphs, the facts are common and the legal issues and aspects arising would be common, would be similar, would be identical. Facts are identical and the issues and aspects of law arising would be common, the court decided to take up for hearing both the proceedings together and simultaneously. Paragraph. As the court addresses the controversy involved in both, the basic controversy involved in both, the paramount consideration is the welfare of two children named Master Tiago Monte da Silva Sidhu, aged about 8 years.
Yes, ma'am.
And Miss Ines Monte da Silva Sidhu, aged about 7 years, born out of the wedlock of the parties. The parents at present, seems to be strewn apart with rival allegations and differences, apparently in view of some incident. Occurred on 26th November.
25th, my lord, sir. 25th November.
25th November 23.
2023.
Be as it may. Paragraph. Learned senior advocate Miss Jaina Kotari, assisted by learned advocate Mr. So and so. Complainant in the contempt proceedings. Submitted that the respondent wife is bound to hand over the custody of the two children. She submitted that the children studied at the Bangalore International School, Bangalore, during last 2 years. And that because of non-compliance of the directions of the family court to hand over the custody, the education of the both has been badly suffering. She submitted that the wife forcibly took away both the children from Bangalore to Goa, and that she thereby perpetuated the contempt of the court by not handing over the custody, rather keeping the custody with her, keeping the custody of the children with her only. It was further submitted that because of the conduct of the wife, the petitioner father is not able to even enjoy the visitation rights granted by the family court. On the other hand, learned senior advocate Mr. Nagananda, assisted by learned advocate Ms. So and so, stated that the children are in safe custody of wife. According to him, both the children have got admission at a school at Goa and have been studying. Full stop. This statement, however, was disputed by learned counsels for the husband. Full stop. Before the court proceeds to consider the rival merits in both the contempt application as well as in the writ petition, since the controversy essentially involves human element and the relationship between the minor children and their parents, which again involves the future of the children, the court as loco parentis, deemed it proper to have interaction with both the children at future date. Full stop. Both the children are presently not at Bangalore, but as stated by the parties, are at Goa with their mother. Full stop. In the context of the above short background, comma, having deliberated the subject matter controversy for some time with help of the councils for both the sides, comma, in view of the broad consensus arrived at between the parties, following interim arrangement is directed. First, the respondent father, the petitioner father, the complainant father has agreed to travel to Goa on to travel to Goa to take both the children and the wife.
First one. Alternatively, if you do not do it, then second.
And to bring them to Bangalore. Full stop. The father will be traveling on
We can travel tomorrow, my lords.
On-
Tomorrow
on-
evening. We can travel tomorrow.
She does not bring the children. No, she will be able to bring.
You are agreeable?
My submission, my lord, was that she.
I did not get.
Sorry.
So following arrangement is made, one, comma. Learned senior advocate for the respondent wife stated that the wife with two children will travel from Goa to Bangalore on whenever,
On 29th.
on 29th of
This month.
February,
March.
March 2024 to meet the husband. Paragraph. Responding to the readiness of the wife to come to Bangalore, comma, the learned counsel for the petitioner has stated upon instructions that the expenses for traveling from Goa to Bangalore for all the three
Yes.
will be borne by the husband. Full stop. It is provided that by whichever mode of transportation the three may travel,
By flight,
comma,
my
the
lord.
husband shall reimburse the expenses.
No, we will book it, my lords. We'll book the tickets and we'll
Whatever.
share it, whatever.
Booked it. It is stated that the tickets would be booked by the husband for all of the three.
All three, yes.
Yes. It was further agreed and given out to the court that the husband shall also make arrangement for stay of the wife and children, both wife and children,
Wife.
both the children.
Children to, my lords, children to be with me. I'll make arrangements for the wife to stay.
Wife.
Yes, yes.
Wife, you are agreeable.
Yes.
They are
Right.
agreeable to stay in
At
the
a-
house,
at a-
but
at
they
a-
don't
No,
want
no.
My
to-
submission
At
only
a
was,
appropriate
At,
place,
yes, a decent place will book.
other
my-
than not necessary.
Not not the house, somewhere
house
close by
itself.
we'll book.
Thinking and stay together at an appropriate place.
Yes, we will make some good arrangements.
Full stop. It was further suggested by the husband and concurred by the counsel for the wife that the children shall stay at the father's place during their stay at Bangalore. Full stop. The court so directs. The court directs that the children shall stay at the father's place. Full stop. The wife can also stay at the husband's place if so desires.
No, my lords, there,
Why?
my lords, I am some instructions that may cause some difficulty. We'll make arrangements for to stay. They may meet, we leave it to them. We will not come
Lord's intention was.
to meet and some,
So
yes,
that
yes.
loading-
I get it, my lords. We will certainly
could be- sorry.
not come in the way of that. And we will encourage that parties, in fact, try to do that, but let them not stay
During
there.
the
Probably
stay
there
of the
could be
wife,
some mediation efforts also.
during the stay of the wife, who may stay at any place as may be arranged,
Yes.
comma, the wife shall have right to meet the children after intimating the,
Even at the place of husband.
even at the place of the husband, after intimating the husband. Full stop. It is expected that both the parents and child shall meet and mingle during their stay at Bangalore. Full stop. Next. Both the child names so and so Master Tiago Monte de Silva Sidhu and Miss Ines Monte de Silva Sindhu shall be brought.
Yes.
Shall be brought before the court on the next day of hearing of the contempt
On
petition.
first,
Next
my
day,
lords?
next day of the hearing.
On Monday, 2 o'clock or 1:30
Will it be in
afternoon.
chambers?
Yes,
That
in
is-
chambers.
That is on 1st of April, 2024. At what time?
My lords, any time afternoon, if my lords is convenient,
2:30?
afternoon, 2 o'clock, 2:30.
At 2:30?
Yes.
At 2:30.
Can I just seek?
Foresaid the arrangement and the directions received shall be without prejudice to the rights and contention of the parties.
Could I just make one clarification, just so that it is clarified?
Come to court without baggages.
Yes, yes. My lords, now.
Free
only-
mind.
Yes, my lords, I take that with great respect. My lords, on Friday when they come, we'll book the tickets. We'll share it with the councils so that tickets booking and arrangements are done. On Friday.
They may do it and you read.
Either way, but we to make it easier, we can also do it.
that
Can
way
we pick up?
They may book and you reimburse.
They can directly
the-
contact, my lord, husband, wife, after all, they know each
We
other's
will-
mail IDs.
the
They can
only-
communicate directly with a copy to advocate on record for information.
That
Otherwise,
also we may
They are
do.
sending to me and my sending to them.
My lords, that may also they may do. My only small anxiety is because in the past, despite orders, there has been difficulty to hand over. Can we agree, if the other council is also fine and my lords are also fine, that once their tickets are booked and they come, the father will pick up the children from the airport or any place wherever they are supposed to be dropped, where the mother is supposed to be dropped for her residence. He can pick up the children and take them so that there's no confusion, because my lords, in the
But
past.
we are not exchanging war criminals.
That's true, my lords.
We will take the
Unfortunately,
children to
things
their
have-
house.
Love and affection. Take chocolates, go to the children.
Of course.
You
We'll
also
take them
tell-
to the house, my lord.
Yeah, they have some apprehension
No, we
because
have
of the
that.
conduct of your client in Goa, despite the order.
Yes.
In respect of sports.
I have a
event.
different story, my lord. I don't want to raise it. I don't
That
want
is
to
the
raise it.
difficulty.
I have number of things to
That
say.
is the difficulty.
Yeah, the difficulty is if you don't cooperate.
It sounds like arranging the exchange of some heinous
The line of
criminals, but
control.
my lords, that's not the
This we
intent.
expect, my lord has made it very, very clear with the very, very sublime things it has been done.
Yes, I'm grateful.
Conduct
my lord.
yourself little tall so that we may not draw adverse inference on the next date of hearing.
I'm
You
grateful.
want a further direction that the wife and children shall straightway go to the husband house and children will leave there, will be left there.
My lords, that may help, my lords. That may help that she will come and
Definitely.
drop the children.
Upon reaching Bangalore,
my
the
lord,
wife along with the two children shall straight go to the house of the
House of
husband
the-
to leave
Yes.
the,
Yes.
Yes, my
to
lord.
leave the child,
She will take the children and drop them in the house.
Great.
the child at the house of the husband and
Yes.
then shall.
And
That's
And yes,
and-
grateful. Great. Great.
Or madam, she wants. She wants. Let her there. You have to take the call of the wife. If wife
Of course,
wants
of
the
course.
children,
If he call, yes,
because she
yes.
is mother.
Yes, 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 yes. my
Even
lord.
if the mother's mother, there's my client's mother, my lord, is not allowed. If she is allowed, she's even willing to stay. That's what she has told us.
Let's
Let it be.
step by step.
She is willing to stay in their house alone. But they seem to
They
have
are saying-
We'll
apprehension.
make arrangements.
Let us see first day, not how it goes, and then we.
That's what.
Only thing is night, if at all the kids make some these things, I hope they are okay with
These
that.
directions are there. Yes. But if the wife is ready, but if the husband wants to stay, make the wife stay in his house,
Correct.
then don't say the direction doesn't contain.
No, no, no.
Correct.
Please.
No, if they are okay, then she will stay.
If there is a change of mind, you don't, this direction will not come in way.
Please.
Certainly, my lord, certainly.
All.
Great.
Grateful. much,
Send
much.
over to first of
Grateful.
April.
Mediation. Lord, since all of them are going to be here, my lord, for the 3-4 days together, I only thinking, my lord, whether one sitting with mediator in the family court may help things take it forward. After all, mediation, if it works, otherwise it doesn't work.
My lords
In
are
that
anyway
2 or
going to
3
meet
days.
the children or parties in chambers. My lords are anyway going to meet.
You may be right, but let us
Let
court
us,
interact.
yes,
Please,
So that.
Yes.
it's a-
next week we can see. my lord.
grateful.
Number 20.
In this matter, my lord.
My application for change of land use came to be rejected. The learned single judge dismissed my writ petition, my lord, by wrongly construing that the master plan had reserved all agricultural land in Gabadi village as a no development zone. If I may just take my lords directly to page 232, which is the master plan. 232,
It's
my
on
lord, in
the-
volume 1.
On the premise that once the land is comprised in the master plan, there need not be conversion at all on that premise.
No, no, my lord. The court has held that agricultural land cannot be converted for any other land use by wrongly reading the proposed land use analysis in the master plan. If
There
I
is
may
no
just
such,
take,
no prohibition as such in the plan.
no, no, ma'am.
Where is that?
May I just take my lord to page 232?
It's 230. Yes.
My lord, on the far right of the page, below the key map is the index. Below that is the proposed land use plan, Arohalli conurbation. My lords have it.
Page
Page
232.
232, on the right, far right corner, my lord, on the
Ah.
fold, where just below the key map is the index, below that is the proposed land use analysis. My lord would see that agriculture is 0%, which basically says that in Harohalli conurbation, 0% of the land is reserved for agricultural use. The learned single judge has made, my lord has, if I may.
How he has construed it?
Has construed it as being a no development zone, that no agricultural land can be converted for.
No, merely because. So this is the master plan for planning.
For Kanakpura local planning
Planning
area for Harohalli conservation.
Because it is shown as a zero agriculture
Yeah,
that
the
way.
no development zone, the court has construed. May I take my lord to the relevant portion of the order, page 4.
So what was your prayer before learning single judge?
For a mandamus to the planning authority to
Change.
allow my change of land use planning.
From
But from agricultural to residential.
So that is for.
That's what. Notice.
But then what you are showing is not relevant.
My lord, if my lord would see page 40.
Oh, it is permissible. He construed it that.
Lord, I take notice.
Notice.
For,
Number 1.
Heard learned advocate.
AGA for one.
What is your name? Shruti Chaganti for the appellant and learned additional government advocate is Nilofer Akbar for the response. Notice learned additional advocate waives accepts notice on behalf of
Respondent number 1.
number 1.
My lord, may I only request, my lord, these applications are of the year 2018. On 2 occasions, the court had to issue a mandamus to the planning authority to consider my application pass order. Now, this is the 3rd round of litigation. May I seek a short date? All parties are government parties. A short date for
Now,
disposal.
notice will
16th
have
of
to go, they are an authority.
16th April. Anybody is to be served by you?
Lord, respondents 2 to 9, they were not present before the learned single judge also.
So learned advocate for the petition is permitted to serve the copy of the petition to the appeal,
to all the respective councils who appeared before learned single judge in the writ
My
proceeding.
lord, response 2 to 9 were not
This
there.
appears to be very small issue.
My lord, they did not appear before the learned single judge.
They had not appeared at all. It was dismissed without notice.
No, no, that's not the case, my lord. It was,
Please see the
it was
order.
argued for over a long period
No,
of time.
anybody appeared for the other side?
Yes, my lord. For the
Here,
planning authority, Mr.
Here,
Yogesh
names
Naik
are
was on record.
Names are-
He's a government.
So serve the copy,
Panel, my lord.
if you can.
Yes.
But only government advocate appeared, not the counsel for other authorities
Other
at
is-
all.
Planning authority appeared, my lord. They filed objections, government filed objections.
All right, forget it. It will be open for the learned advocate for the applicant to serve copy of the appeal to the councils for the other respondents who normally appears,
Right.
irrespective of their appearing in the-
Appearance before single.
before the learned single.
Seal number 23.
For complainant in this case. Lord, this is against an interim order. We have filed a counter also.
Though it is interim order, my lords, a specific direction was issued. Kindly see the order at Annexure A, page 18. Lords, and continuously, my lords, this is the fourth contempt petition initiated against accused number 9. Lords, though notice is served, he remained absent. My lords, order is at page 18, Annexure A.
But it's an interim order.
Please, my lords. Now kindly see, my lords, in another connected contempt proceedings, my lords. He appeared, he filed, my lords, unconditional affidavit before the court. Then, my lords, he made allegation against the honorable judges of this honorable court also. And that is recorded, my lords. I have produced that along with, my lords, the additional documents application. Kindly look at the conduct of accused number 9 and the documents relied upon by the, my lords, state authorities are, my lords, prior to their own document, which is contrary to, my lords, their endorsement, which I have produced at page number 200 and, my lords, 35. There they say, my lords, he has committed contempt of court.
That's all right, but WP is still pending.
It is still pending.
Work out your remedy there.
My lords, now for having violated the orders of the court, I am before my lords. And even according to them, my lords, he has committed contempt. Page 235, my lords. Of course, it is in Kannada, my lords. My lords, in spite of service of notice, he remained absent.
You can seek arrest and detention.
Yes,
also.
that is what, my lords. That is why I am requesting this honorable court to issue, my lords, warrant against accused number 9. And kindly look at the conduct, my lords. Kindly see the.
All, Mr. Rajshekar,
Yes.
we have consistently taken the view that where WP still pends,
Yes.
generally we will not interfere in contempt matters because everything is open to you to say to the judge who is considering hearing your WP.
Please.
On that principle, it's not that we don't have jurisdiction.
Please.
We have adopted a particular norm because you have option there.
May I request my lords to turn to page 235 for a moment. Page 235, I'm sorry, my lords, it is in Kannada. I'll file a translated copy, my lords. Page 235. Second paragraph. They say, my lords, he has been, my lords, violating the court orders.
That will be a ground for grant of relief at the hands of to secure relief at the hands of the learned single judge.
And they have issued endorsement also. Now, I can understand, my lords, in normal course, if, my lords, the interim orders are violated.
Wherever there was violation, Lord, we have taken action. We have filed contempt counter affidavit also, Lord. FIRs are registered.
That is prior to this endorsement.
On
Kindly see
29/10/2023, that is subsequent to this endorsement. Annexure K.
May I request my lords to take my additional application file seeking for production of additional documents for a moment.
No, they are to substantiate your claim that there is contempt.
Yes.
We are not examining it.
Yes.
What we are telling you is consistent with our judgments. Go before the learned single judge, before whom the matter is still pending, and tell him he is doing like this, he is not obeying your order. Learned judge in his discretion. Our powers are coextensive with powers of the learned single judge only, not beyond that. They are less than that actually.
My lords,
Therefore,
in normal course, I am not, my lords, I am not, may make
one request, my lords. In normal course, my lords, I would have agreed, my lords, to go before learned single judge. Here is a case, my lord, that is why I am requesting my lords to look into the conduct of accused number 9 for a moment.
You have seen
Wherein
that he has made some allegations against judges also. That's all right. Making allegations against judges is not a new thing. It has been there since last 130, 35 years. Therefore, tell the same judge, go and tell him, he's speaking like this. Take action that way.
The language is used against the judges of this honorable court, my lords.
We have seen that also.
Order dated 31st August.
Please, my lords.
It is under contempt. Page 19.
Yes,
19 and
yes.
20. Yes.
While the court has heard learned senior advocate Mr. So-and-so, with learned advocate Mr. So-and-so, in this contempt proceedings, it is evident that the order brought under the contempt jurisdiction is interim order passed by learned single judge in the writ petition, which is pending at large on its merits. The order dated, not the order dated 31st August 23 is one where the notice is issued and respondent 9 is restrained from violating the court's order. The complaint about the breach, alleged breach of the restraint order is not liable to be examined in this contempt proceedings, as the court is not inclined to invoke the contempt jurisdiction when the petition is at large on merits to be considered by a single judge, where the complainant therein could raise the grievance about the non-compliance and work out his rights and remedies. Full stop. No case is made out at this stage to exercise the contempt jurisdiction. Accordingly, this application is dismissed.
May I make one request? Since lords have permitted me to work out my remedies, my lords, before the learned single judge, but instead of dismissal, my lords, disposed of. Otherwise, my lords, tomorrow they may take up a contention that my lords dismissed.
Contempt proceedings stand disposed of.
Great.
Non-filing of complaints, seal number 24.
I request my lords a week's time to file the complaints affidavit, my lords.
The sufficient opportunity has given my lord to file affidavit.
Direction was to consider
the representation. He had, the petitioner, my lord, had sought for an allotment of a particular site.
in lieu of revenue site.
Yes,
lieu of a revenue site in Junjama's case. That, my lord, request was
Sir, 11
refused.
of the
However,
upper
my lords, the
proportion
learned
kindly
single judge directed that his representation seeking for allotment of an alternate site to be considered by the BD and an appropriate order be passed. We're in the process of passing an order. My request for a week's time, my lord, will file the complaints. My lords. I had a word with the officer in the morning.
Can we record his submission and drop so that it will be aggravated contempt if they do not do?
Please, my revenue state has been acquired in the year 2003, my lord. Since they have not provided any alternative site.
No, they say they will abide by the direction within 1 week.
Please.
It is the following directions passed by learned single judge in order dated 14th December 22. In the proceedings of writ petition number 18988 of 22 that are brought under the contempt jurisdiction of this court. And quote the order, paragraph page 6 of the order entire. Learned advocate Mr.
B. Vachan, my lord.
So and so appearing for the Bengaluru Development Authority stated before the court that the directions of learned single judge shall be complied with within 2 weeks, please, from today.
1 week?
As my lord's
They don't
directs, my
comply,
lords.
again you have to come. Therefore, 2 weeks from today. You are waiting since 22, so.
Yes, my lord.
2 weeks from today, full stop. The statement made on behalf of the Bengaluru Development Authority satisfies the complainant appearing through learned advocate Mr.
Vasant Kumar. H.T. Vasant Kumar.
Vasant Kumar. Full stop. In view of the statement, the contempt proceedings are closed with observation, however, that non-compliance of the directions within the time stipulated above shall expose the respondent authority to aggravated form of contempt.
Obliged, my lords.
Seal number 25. Mr. Leela P. Dev-
Your Lordship, I will say for complainant. Your Lordship, Learned Single just directed the respondents to
In this
restore the
matter.
revenue entries. They did not do, Your Lordship. I filed
And
contempt
read.
petition. After the contempt petition is filed, Your Lordship, they files an affidavit stating that, Your Lordship, the order
Now
passed
we
by the
have
Learned
filed a
Single
writ appeal, my lord. This may be called along with the writ appeal number 1289 of 23.
that is disposed, my lord. That is disposed.
Disposed of.
Yes, my lord, that is disposed of. That's what I wanted to mention, my lord.
What do you have a copy? Please share a copy with him. Restore the subject entries.
Yes, my lord.
Your appeal has failed.
Yes, I'll seek instruction. The last may kindly grant.
Your Lordship, kindly see the order. Your Lordship,
2
what
weeks.
happens is, Your Lordship, please.
A direction to restore entries.
Please, Your Lordship. I understand.
Certainly heavens have not fallen down. Entries in the revenue records.
2 weeks time. I'll seek instruction.
You have to restore, you have to come with the
Yes, yes.
compliance affidavit.
Yes, since appeal is dismissed, Lord.
Yes. If you are agreeable that in the event they do not do, it would amount to aggravated form of contempt. With that, can we dispose of so that they will be under more threat?
Please, Your Lordship, then
So
Learned.
that will.
Learned, when the present contempt proceedings came up for consideration, learned advocate Miss
Leela P. Devadiga.
Ilapi Devadiga vehemently submitted that though writ appeal is dismissed, the authorities have not restored the revenue entries, which was the direction issued by learned single judge and confirmed in the writ appeal. Full stop. Learned government advocate Mr. Mahendra stated that the order passed by learned single judge and confirmed in the writ appeal shall be acted upon and the entries shall be restored in the revenue record within period of 10 days from today. So,
4 weeks, Lord, because.
For restoration.
I don't understand why.
Lord, now,
2 weeks later.
no, because this reason, Lord, that the elections they are, Lord, assigned with the election duties now.
Your not even revenue inspector, the Talati will do that under 128.
No, no,
It is
Tahsildar has
that-
to do. Tahsildar.
The order is
Tahsildar.
against the Tahsildar. The entries are always done by Talati, then go to revenue inspector, then to the Tahsildar.
it is a matter of stroke of pen. Or,
That's what.
nahi? What
Yes,
process?
pass in order.
There is
For like 2 weeks.
2 weeks.
The contempt proceedings are closed since the statement as above is made. It is our observed that non-compliance shall expose the authorities to the aggravated form.
Beautiful, my lord.
Number 26 to B.M. Siddhappa.
Lord, I appear for the appellant in the appeal. Comply, my lord. Next to.
Appeal number.
Yes, Lord, I'm filing complaints affidavit.
Compared with.
Yes. We have paid the EL.
You have paid the allowances now.
Yes.
Why do you not share with that to the citizen Why unnecessarily cases should pile up here? You should have said, we have complied, take this order.
Yes, but
That is one of the features of welfare state.
last minute.
Any cases come here because you do not comply. If you comply and report to the citizen, whatever remedy he will avail, he will avail.
Yes.
Kindly grant 1 week's time, I will check it up with.
5,12,376 has been paid.
Paid.
That satisfies us.
There, they have paid the interest for delayed period.
That, where is the direction? Show that. Where is the direction?
It is only, the direction is my lord consequence. Direction issued to the state to pay the petition allowances and other benefits at par with the district judges for the tenure that they have or in appointment as a president of the respective.
Where is the direction? Sir, we are asking you, where is the direction to pay the interest?
The consequence, because.
No, it never consequence.
Because what they were paid is now they have paid. It has to be paid long back. The order was passed in the year 2021.
Following direction was issued by a single judge while allowing the writ petition number 8149/15 on 15 February 21 and court the vacated portion. When the breach of the aforesaid direction was complained of in the present contempt proceedings by the complainant appearing through learned advocate Mr.
Siddhappa.
So-and-so, Sinnappa, and a learned government advocate Mr. Mahendra. You are.
My lord, I appear in the appeal, my lord.
Connected appeal, it become
The
infructuous.
government advocate Mr. Mahendra as well as Ms. Nilofar Akbar appeared to produce a memo, compliance affidavit, wherein it is indelibly stated that the amount of rupees 5,12,376 has already been paid in compliance with the directions of learned assembly. This marks closure of the contempt proceedings as the directions are complied with. The contempt is closed. Contempt is disposed of as closed.
Appeal remains. Writ appeal remains.
Writ appeal become infructuous.
Writ appeal remains
infructuous.
My lord, but there are objections in the writ appeal, my lord, and maybe, my lord may grant me. Writ appeal may be dismissed as infructuous, but I'll
Infructuous.
comply with the office of corrections, my lord. I wouldn't want it to
So
be.
separate order and writ appeal. As the order under challenge is acted upon unconditionally by paying the amount as directed to the respondent original petitioner, this writ appeal has become infructuous, as rightly stated by learned government advocate. We don't take up anything.
Like,
Number 27, Janardhan Ji. Actually, C is the order.
Not in this matter, I stay for a week's time, not because I could not prepare for the.
But in the connected matter, not writ appeal, but only a direction has been issued to consider.
No, if he is agreeable for Lord the consideration, simpliciter, we have no objection. Lord, with the light of the observation made by the learned single judge, Lord, we have to consider.
Discretion is given to them to consider with the relating to the particular order. Now, kindly see, Annexure A, which they issued by the government. But can consider that and pass appropriate orders. So kindly see.
Order is at page number 37, operative portion.
So where is your writ appeal? 943.
943. 943 connected.
Where is it?
Connected.
So this is the representation regarding payment of some salary.
No, extension of UGC pay scale.
Pay scale.
UGC pay scale to the lecturer who has been appointed in private aided college.
The direction is from the date of regularization, they called upon to consider.
If what he says is, If you are in principle agreeable for consideration as an open case, then he says we would consider.
That they have done it, my lord, from 2014. This court said, my lord, the learned single judge said, as per the government order annexure K.
Then requires consideration.
So we will grant time and
Financial consequences.
Lord, 180 days delays, they are not there.
then notice in, you accept the notice.
You accept the notice.
I will
We
accept.
condone the deal.
Delay we shall condone.
That I will accept. And so far the college is concerned, I think the last, say formal party.
College is a formal party.
Yes.
And so, because they have no. So,
Notice to college can be dispensed with because payment is to do everything. Delay.
IA number. So and so hard learned government advocate Mr. Mahendra for the applicant state and learned advocate Mr. So and so the respondent who accepts the notice in this interim application.
But I will accept the notice for R1.
For number 1.
Or respond number 1, I will.
So who will be for number 2?
Second respondent is concerned, but it's a college formal party, I think.
Formal party.
And take
This
notice. to
could
the
be
council
number
of
1.
the-
This application could be considered in absence of respondent 2 is a formal party. Therefore, at the request of learned government reader, respondent 2 stands deleted for the purpose of this application from the area of respondents. Full stop. It is the delay of 160 days.
181 days.
181 days.
181 days, which is sought to be condoned. The supporting affidavit spells out the grounds for passage of delay leading to, passage of time leading to delay. Full stop. It is due to administrative reasons. And the reasons attributable to the decision-making process at the end of the applicant government that the delay has occurred. Sufficient cause is made out, delay is condoned. Application is allowed.
Obliged.
You are not appearing for college?
No, I am for the
employee.
lecturer. my
Your
lord.
employer?
Teacher.
Who appeared in college?
But they are also.
Yeah.
they are
Nobody
also-
appeared for college.
No, nobody appeared for this.
Also,
Nobody appeared.
for R4 also government advocate took
For
notice.
college only.
Okay.
2 weeks later.
Number 28. The Vasant Kumar HP.
Led by me.
In this case, I am offering for the respondent, my lords. Was 2 weeks time may be granted to file the compliance affidavit, my lords. My lords, in the last date of hearing also, BD has taken time to file a compliance affidavit, my lords.
It's a positive direction. Currently, page 10 of the order.
Page 10, my lords. The direction is
Here
to,
also, my lord, my revenue set acquired in the 2003. Order came to be passed in the 2016 to provide the alternative sign. And there is a specific positive direction to alert the alternative sign.
When was notice served on you?
my lords, I have filed a wakalat.
There is a positive direction and you have not appealed also.
My lords, 18th January 2024, my lords, they have received the, we have filed the wakalat, my lords.
We are not concerned with your wakalat.
Yes, my lords.
We, citizen wants the user effects
Yes,
of the litigation to reach his hands, nothing beyond that.
My lords, 1 week time is granted, my lords, by next week.
Comply.
Yes, my lords, we will file the compliance affidavit, my lords.
Aggravated contempt if it does not happen.
We will allow the, which site, 368 or other?
My lords,
Are you clear in your mind?
Option is given.
The original site directed to be allotted is allotted, is available or allotted to anybody else?
my lords, I will secure the instruction. My lords, my lords, the instruction is that, my lords,
You might come out with the allotment of third site. How do we? Tomorrow.
My lords.
Find out, then we'll dispose of. Tomorrow
Next
at
week.
11.
Next week, my lords.
Why next week? Then we dispose of next week. Are you aware that, are you satisfied with this order?
No, my
You are
lord,
not
earlier
happy
it
for
was found to allot the,
the directions contained in order dated 31st August 23 of learned single judge while allowing the writ petition number 13583 of 23 are inter alia that the respondent, who is the respondent? Bangalore Development Authority shall allot site to the petitioner at measuring 30 into 40, which is land bearing survey number, which is site number 368/5. It is further observed by learned single judge that if the site is already allotted in favor of any other person, then the petitioner may be allotted any other site in Sir M. Visvesvaraya layout. Full stop. When the contempt proceedings in respect of the site directions come up for consideration, when the present contempt proceedings in respect of the site directions come up for consideration, learned advocate Mr.
Shravan, my lords. Shravan.
For the Bangalore Development Authority.
Appearing on behalf of Sachin BS, my lord.
For
Sachin
In
BS.
BS. We'll mention Sachin BS.
Sachin BS. He is in the court.
Yes,
He is also panel.
Yes. Stated that the directions of learned single judge shall be completed within 2 weeks.
2 weeks.
2 weeks. Full stop. The statement made by learned advocate before the court and recorded in this order satisfies the complainant appearing through learned advocate Mr. So and so and so. Contempt proceedings are accordingly closed. However, observation that non-compliance shall render the respondent to be exposed to the aggravated form of contempt.
Number 29, hearing on applications, Ramatullah Sharat.
Appearing for the petitioner, your lordship. Your lordship may kindly agenda matter for 2 weeks, your lordship, since my senior is not in town.
2 weeks.
Please, your
I
lordship.
appear for respondent number 4, your lordship.
We need
Dismissed
to-
already.
And we need to
The
engage,
matter
we need to engage the
has
senior
been
counsel for this.
dismissed by the learned single judge.
It is regarding what?
Election of,
Election of Wakaf.
election to the Waqf board.
Wakaf board.
That election was 16/12/2020. Respondent number 5 was declared as an elected member to the board. But one joint action committee of the board, they have filed a writ petition challenging his election. That came to be dismissed by the learned single judge. Writ appeal came to be filed. In the writ appeal, they make a submission saying that some of the submissions that are made before the learned single judge have not been considered. Then the division bench of this report came to the conclusion that if that is the case, liberty will be given to you to seek review of that order. That writ appeal came to be disposed of in that fashion. Then they filed a review petition. The review petition came to be dismissed. That has become final. So the contest to the election of this respondent number 5, the board, it has become final. All these writ petitions are for the same relief.
So why again writ petition? Same challenge.
Same relief. But one person, sitting member, he files a writ petition before the learned single judge. He withdraws that writ petition, seeking liberty to file.
But this petitioner has filed for the first time.
This petition, yes, for the first time. Other 2 writ petitions.
Others have challenged the election of number
Yes,
5.
yes, yes.
And they have failed.
Yes, they have.
Kindly fix a date for final hearing.
For you, there can't be a separate ground of challenge in election.
Yes, your lordship.
In election, for you, in the election issue,
or election of one of the respondent,
Very same election.
very same election. Even if you have a ground different than ours in the earlier proceedings, we can't.
What is the tenure of the
5
post?
years, my lord.
5 years.
That comes to an end in January 2025.
No, I think within 4 months. It will.
Yeah?
Another 3-4 months, the term will be expired.
How? That will be
Now,
15/9/2020.
no,
My
that
lord,
is
in
the election of
January.
respondent number 5, but the remaining portion of the
Remainder of the period.
remained. Earlier, it was in 19, board was constituted. So that period of the board will be concluded in another 4-5 months.
It was for the casual
5
casual
years,
vacancy.
5 years.
ಇದು ಬೇಡ ಇದು ಮಾತ್ರ ಇದು ಕೊಡು. ಇನ್ನೊಂದು ಸೆಟ್ ಕೊಡು ಫೋಟೋ ಹಾಕ್ಸ ಪಿನ್ ಮಾಡಿ ಇದು
You want your
ಫೋಟೋ ಹಾಕ್ಸ
will grant time.
Week after.
What are you? But the orders of the other.
Yes.
What is in writ appeal? Connected appeal?
There is no writ appeal here.
No, no,
There are 3 writ petitions that are conducted. 1 writ petition by way of PIL for the same relief. Other 2 writ petitions were before the learned single judge. They are tagged on to this PIL.
Now this Muttavali will be representing bar council?
Yes, he is represented.
By ex officio.
Ex officio. Nomination.
Nominal, not ex officio.
The collegium is the bar council.
So that is the main grievance. He is in bar council.
My lord, ex-member of the bar council is thought to be nominated by the government, so he is aggrieved by that.
He could not have been.
No, now with us having issued the corrigendum, my lord, we have said 2 members can be appointed.
Honored Advocate Mr.
Muhammad Anwar.
Fixed time on the ground that the arguing counsel is not available. On the other hand, learned senior advocate Mr. So and so stated that the challenge to the election of this 5 is also the subject matter, which is the subject matter of the present proceedings, has been concluded in the other writ petitions filed by others. In that view, however, keeping the rights and contentions of the parties open, to be listed on. And
After 2 weeks, your lordship.
16th of April at 2:30.
Much obliged.
Number 30, Vittal BR.
My lord, I'm for the petitioner, I'm online, my lord. For the petitioner, WP 511 of 2020, my lord.
On behalf of respondent number 4, 5, 6,
No.
and 8, my lord. Senior
Lord, so-
counsel is engaged in quote number 11 in an arguments right now. Kindly a small pass
Well,
over, my.
My lord, so the previous date of hearing, the government advocate undertook that they will file objections in the other 2 writ petitions also, my lord. Till date, they have not filed the writ petitions and many IAs are also pending, my lord. If the pleadings are complete, then the matter may be posted for final hearing.
Yes, my lord, the matter can be posted for the final hearing because the government has already placed their objection in WP 511 on the 17th of February 2021, my lord.
You are seeking time?
Yes.
After vacation.
Grateful.
Obliged.
My lord,
In the
the date may
third
be
week.
fixed, my lord.
Third week of the year.
Any date might be fixed, my lord.
Date 20th June.
Obliged.
So it is old one.
December.
Old one, so let it be earlier. 11th of June.
Obliged.
31 attend, seal number 32. Ganpati Bhatt.
Yes, sir. My lord, please come to my lord, annexure B. Stone crusher license was issued to me, my lord, in the year 2013. Page 36, my lord.
Date of the license?
My lord, date of the license is 23/11/2013.
Under the Stone Crushers Act?
Yes, my lord. Karnataka Regulation of Stone Crushers Act, my lord.
Yes.
And the rules framed thereunder.
That is for a period of?
My lord, it was initially, my lord, for a period of 3 years. Then, my lord, it was valid till 22/11/2016. Therefore, my lord, 3 years would be, my lord, from 23/11/2013 to 22/11/2016.
16.
There was an amendment, my lord, to the Act, Section 5. Therefore, my lord, original licenses, my lord, stood extended. And therefore, my lord, this also, my lord, came to be, my lord. I filed a writ petition. Page 40, if your lords has come to, my lord, 40.
That amendment took place when?
My lord, the amendment was in the year 2016, my lord.
Was it before your license expired or
Yes,
after?
my lord. Yes.
Before.
There is no dispute about this, my lord. That, my lord, my license, my lord, was renewed.
License is renewed in terms of by statutory renewal.
Yes, my lord. And an order also has come to be passed by your lordships.
Page number?
40, my lord. Page number 40, annexure D. At 42, page 42. Writ petition is allowed, para 5, my lord. Page 42, para 5. Extend the validity of the period until 23rd of November 2018.
So this validity period got extended because of the amendment?
Yes. Yes.
Automatically?
Yes.
For how many?
Well, till 2018.
Further it up to 18.
22/11/2018, my lord.
That is two more.
2 years.
2 years.
Actually, it was extended to 5 years from, my lord, the original.
From the original period.
5 years from the original. So, my lord, it got extended till 2018. In fact, page 43, the authority also, my lord, passed an order to that effect in terms of the order passed by your lordships. This license is valid till 22/11/2018.
Yes.
I filed an application for extension, page 44. Before, my lord, the expiry of the valid, the lease period, the license period, I applied, my lord, on 22/10/2018.
So extension beyond 18.
Yes.
Where is that?
Page 44, my lord, 44.
Yes.
One month prior to expiry.
Yes.
Yes.
Then, my lord, there was an amendment, page 68, my lord, if your lords has come to, my lord, 2020. My lord, that application was kept pending. No orders were passed. No orders were passed.
No deeming provision in the act.
Please come to, my lord, page 68. There was an amendment in 2020. English translation, my lords, get that at running page. Sorry. 75. Stone Crushers Act, the Preservation Stone Crushers Act.
So amendment in 2020.
Yes, my lord. As per which, my lord, it gets extended automatically by 20 till 20, my lord, for a period of 20 years. Subsection 2. Subsection 2, my lord, of section 6. Section 5, sorry.
Page 75.
Yes.
This is a second amendment. Second amendment.
Yes.
With effect from 31/3/2020.
Yes.
Yes.
Then, my lord, what happened was,
how it reads?
My lord, please come to, my lord, page 77. Substitution of section 5. Section 5 of the Principal Act shall be renumbered as subsection 1 thereof, and in subsection 1, as renumbered, for the words valid for 5 years, and for the words for further period of 5 years, the words valid for a period of 20 years, valid for 20 years, and the words further period of 10 years shall be substituted. The following shall be inserted, namely.
So it becomes 20 years.
20 years.
20 years instead of the earlier tenures which were specifically prescribed. That's the interpretation. Any judgment interpreting this?
My lord, please come to, my lord, running page 80.
Page 77 is your translation or?
My lord, original is here, my lord. Your Ashmet.
Also here.
Regulation put the act put. Five two, my lord, section 5, subsection 2. Subject to payment of such annual regulation fee.
No, this amendment is in which law?
Please, my lord. Section 5, my lord. Amendment is to section 5. Karnataka Stone Crushers Act.
Yes.
2011. Section 5. A license shall be valid for 20 years and may be renewed for further period of 10 years, subject to the fulfillment of the conditions laid down under this act and the rules. Explanation: where the license has been granted in the middle of a year, for the purpose of computing the term of license, the remaining part of the year shall be deemed to be an year. 2. Subject to payment of such annual regulation fee as may be prescribed, all existing crusher license granted before the commencement of the Karnataka Stone Crusher Regulation Amendment Act of 2020 shall be deemed to have been granted for a period of 20 years from the date of original grant and shall be extended accordingly.
So pending application, that also will be covered by extension.
In fact, this came up for consideration before my lords at page 80. Division bench of this honorable court has considered this. '84, my lord, if your lords has come to para 3, my lord. Almost similar to our factual matrix. In WP, para 3, my lord, in WP 5405 of 2020, license under section 3 of the said act of 2011 for running the stone crusher unit was granted to the petitioner for a period of 5 years with effect from 20th of August 2013. Before the expiry of the said license, on 21st of May 2018, petitioner applied for renewal of the license. First challenge the said petition is to the decision dated 6th of August 2019 by the licensing authority. Decision is that the action can be taken on the renewal application only after necessary directions and guidelines are issued by the Government of India with regard to the issue of deemed forest, etc., etc. Then, my lord, please come to, my lord, para 5. The deemed forest Barodilla. In this, my lord, there is no deemed forest thing. Please come to para 5. Learned Counsel appearing, page 86, my lord.
Page 8, para 8, page 89.
Yes, ma'am. Absolutely. Yes, my lord. In that, my lord.
The
My
words
lords,
5 years have been replaced
correct.
by the words 20 years.
Correct.
And the words like 5 years have been replaced with There's no.
And after 20 years, my lord, another 10 years also, my lord, is provided under the act. Anyway, my lord, we are now in that realm of 20 years.
What do you say? Mahindra? What's your argument?
Last may kindly see. Against the
Only
order of-
one, my lord, before page 96, if your lords has come to, the order of the operative portion of the order of this court, my lord, in that. We hold and declare. Last paragraph, my lord, at page 96.
We hold and
Declare, as the application made by the petition, both the case for renewal of their respective license granted under section 3 of the act were pending as on 30th of March 2020. Petitioner will be entitled to deemed extension in accordance with the provisions of subsection 2 of section 5, read with section so-and-so amended ordinance. Then, my lord, ordinance became an act.
Ordinance became the act.
Same thing.
What was considered was by the ordinance by the
Ordinance.
division bench.
Yes.
The same means now becomes
Yes.
statute.
Yes.
So far as this judgment is concerned, Lord, this has been recalled by the division bench.
Recalled?
Yes,
And after recall, what happened?
this order.
All right, recalled. Then what happened? It's still
Peti-
pending.
Petition was withdrawn. Petition was withdrawn.
Withdrawn. All right. So we'll ignore this now.
Yes.
Come
So
to the
far as
amendment.
the present issue is concerned, Lord, against the order of rejection, they have filed an appeal before the appellate authority.
Yes. Recalled on what ground?
Because the division bench has not noticed the explanation to section 5(1).
Section 5. The license will be granted to grant middle of the year, same? Which is that
Explanation to
Explanation to 5(1).
5(1).
Where a license has been granted in the middle of the year.
Yes, that has to be treated as full year.
Deemed to be here. That is rounding off.
Rounding up.
How it goes against them?
Now, this was not brought to, because in that matter.
That's all right. In this case.
In this,
It's only speaks of rounding off. Instead of few money, few rupees or few paise, it says period.
in this case, as on the date of amendment act came into force in the year 2020. This lease was expired in the year 2018 itself.
He was granted license, these factuals on foundational facts, let us not differ. 23/11/2013 is the grant of license.
Yes.
That was for the initial period of 3 years. The first amendment, because of the first amendment, the period extended till 22/11/2018. The foundational facts for attracting the provisions of the
Please.
amendment. Then renewal was sought on 22/10/2018. Do you agree that it is true? Correct?
Yes.
The amendment came into effect on 31/3/2020. No decision was taken on the renewal application.
No.
It was taken.
Against which, revision, in this present petition, the challenge is to the order of the revisional authority produced at annexure R. Annexure R. My submission is, Lord, this amendment act of 2020 is applicable for those crusher license which are existing as on the date of amendment came into effect. All existing, the word used is not all existing license shall be deemed to have been. May I read the relevant provision?
All existing crusher licenses
Yes.
granted
Yes.
before the commencement of Karnataka Amendment Act 2020
Yes.
shall be deemed to have been granted for a
period
of 20 years, not even extension. It is extension of the tenure of the license as originally.
From the
fixed.
original rule.
Not even renewal.
Not even renewal.
Subsection 3, my lord, your lords may have it just.
The benefit of extension of section 2, this section shall also apply for cases where pressure license renewal application was filed before
Filed
the
before.
expiry of such, which is pending consideration.
Pending
of the
consideration.
authority.
Hmm.
And for the cases where the authority has rejected renewal application solely on the ground of non-filing of such application 3 months prior to such, but has applied for renewal of the expiry of the stipulated that the renewal of such shall be subject to payment of fine. Even rejected applications will get granted. If rejection is on the ground that it was not filed
Prior to the.
prior to this, if on that ground alone, if application is rejected, two, subsection 3 speaks of two classes.
Yes.
One, the broad object of the legislature is wherever license is granted, the tenure of the license should be deemed to have an extended
Yes.
maximum extent of 20 years, minus the period spent. Broad explanation. The subsection 2 speaks of that one. Subsection 3 goes one step further. The object of the legislature is even where there is rejection, and such rejection is on the sole ground that the application for renewal was not made within particular period before expiry.
No, Lord, but it has to be made before expiry only. May I read, Lord, subclass 2 of 3.
Yes.
For the cases where licensing authority has rejected renewal application solely on the ground of non-filing of such application 3 months prior to the expiry of such license, but has applied for renewal before expiry of license as stipulated, and it has to be before expiry of license.
Correct.
Then there was a stipulation that 3 months prior to the expiry of the license, he ought to have filed an application for renewal.
Earlier rule.
Earlier rule. If he failed to do so, however, if he files an application prior to the expiry, that has to be considered is the intent of class 2.
That will render the class 2 of subsection 3 otious, because the case which you are speaking of would fit into subsection 2.
Lord, the wording is, Lord, 3 months prior to the expiry of such license, but has applied for renewal before expiry of license as stipulated under subsection 1. The renewal under subclass 2 shall be subject to payment of penalty. That is why penalty is covered. Penalty of rupees 2 lakh. Suppose if he files 1 month prior to the expiry of lease, then he has to pay 2 lakh penalty, then that renewal application becomes valid. However, in any case, the renewal application shall be filed prior to the expiry of the lease, is my submission.
That will be a case of lease in existence, licenses granted, all existing license it will be.
Yes.
Your argument is the intent of the legislature, you mean to say,
please,
expressed in subsection 2 is duplicated in clause 2 of subsection 3. But the presumption is legislature does not duplicate. There is such a presumption which Crawford on statutory interpretation of statutory construction says. The first which you are said now, it fits into only 3 will die, 3 will be rendered otious.
Subclass 1, please.
They are distinct categories.
Distinct category.
You can't mix up and then make a argument.
Separate category.
These are the categories very clearly. Benefit of extension of subsection 2 of the shall not apply. One category, second category.
Second category. 2 separate categories are created. In addition to those which fit into subsection 2.
There is nothing like conjoint reading.
The word used is and appears
As
after semicolon.
And on the contrary, divides the category.
Otherwise also.
And for the cases.
Lord, the benefit of extension under subsection 2 of this section shall also apply.
Correct.
Shall also apply for the cases where license, crusher license renewal application was filed before expiry. Before,
That would fit into one.
One.
There is the need for second one. Law should be interpreted in such a way that every provision of statute is given due effect.
The mode of filing renewal application was contemplated in the earlier act.
Correct.
Earlier act where it.
3 months prior to the expiry.
Prior to expiry.
Understood.
Expiry. Now, Lord, because of this amendment, because of this amendment, if the application is filed prior to expiry, it has to be considered for subsection 2 is my understanding.
Wrong. Wren and Martin on English grammar and usage says, where and is employed subsequent to semicolon, it should be treated as a disjunction. It is not and, which will be a super addition. Please see, the object is, the object of the legislation, the legislature in this amendment is very, very vast. It covers, intention is again and again going to authorities, seeking renewal, that will breed lot many problems. Legislature in its wisdom identified it and said, we will avoid the crusher people.
That is the
going to
intent
the
of
officers at all.
Yes,
So 20 years. What are the cases? The cases subsection 2, all cases in which licenses are still alive.
Alive, yes.
Number 1. Go to number 2. All cases where renewal application was filed before the expiry of the license period. Second one. Third one is another category which my Lord has pointed out. Very object is to create separate category. Third one goes, not only your application, your license has expired, even your application is rejected, provided. These are the things. It fits into, at the most it will be in 2, 3-2.
3-2 doesn't spell out with regard to rejected application.
So in this case, his application was
Not rejected.
pending in time.
In time.
Renewal.
Yes,
within-
renewal was unfiled on 22/10/2018.
Then this may not apply
At all, at all.
22/10/2018, he has filed the renewal
Renewal
application. 22/11/2018,
Expires.
it was expired. 1 month prior to the expiry of lease period, he has filed the application.
Fits
But
into
as
2.
per the provision, sub-rule 2 of, class 2 of,
Rejecting only. You
class,
have rejected only.
No.
You have levied penalty or rejected?
No, I'm not rejected also. Now they have rejected.
Now
That
you
is,
have
I've
rejected.
challenged
You
it.
could not have rejected. That makes your case still worse.
no, my submission is not, in order to maintain the renewal application under class 2 of subsection 3, class 2 of subsection 3, it is not 3 months prior to the expiry of lease. It is after the lapse of 3 months. That is 1 month prior to the expiry of lease, he has filed. Therefore, he ought to have paid penalty along with the application. Payment of penalty of rupees 2 lakh. That is a precondition to entertain this application.
To accept your contention, we have to manhandle the text of these provisions.
That's my submission.
But you're asking us to manhandle, that's not permissible to the judges. Fortunately. It will fit into one itself. It cannot be.
Now you want to impose penalty.
Sorry.
You want to impose penalty? That's not your case. You have
Penalty is
simply rejected.
provided under the act. That is one aspect of the matter. Lord,
No, you must be clear.
please.
Are you defending your rejection? Or you're interpreting 3-2
Penalty should be
by
paid.
submitting that the penalty is leviable? What
That's
is
not
your
good.
submission?
Lord, now in this matter, the rejection is on the ground that this crusher is situated within 45, it is beyond the safer zone. Safer zone as contemplated under 6-2. It is within 45
Not
meters.
on this ground.
Not on this ground.
But you are arguing on that you should have informed earlier, so that we could have confined to that one only.
Not on this ground, since your lordship asked. me that.
So then the everything is directed.
Misdirected.
ಅದನ್ನೇ ಮಾಡಿದ್ದಾರೆ.
It's not, Mr. Holla, it's not on the ground that these provisions are misapplied, etc. It's on the ground that it is, let us read the order itself now.
Please.
Let us.
Page my lord, 146.
Annexure R. Page number 146, it starts, translated.
Page 141 Kannada, 146.
146, my lord.
English.
Page number 152, para 5 is relevant. Before that, Lord, para 3, while considering in this regard, page number 151, last para.
Six one B.
Yes. (100 meters) is the stipulation.
Is there such a declaration?
Yes.
Where is that? Where is the declaration?
Declaration to the effect.
Declaring this area. There should be a declaration. The declaration of safer zone for stone crushers under this act shall be subject to the following conditions, namely.
Lord, first we will conduct joint inspection. If it satisfies all these conditions, then only we will not declare it as safer zone and by notifying it.
And grant license.
And grant license.
They have granted the license. Annexure A, my lord, is a safer zone notification.
Safer zone is declared now.
Annexure A.
And your unit is within a safer zone only.
Yes,
Otherwise, they
yes.
would not have granted the license at all. Is your contention.
Lord, for every new renewal application has to be treated as, renewal application has to be treated as new application. And safer zone declaration has to be done by conducting joint inspection.
Where is the renewal?
Lord?
Where is the renewal?
Renewal application they have filed.
Application is for, it is a jurisdictional fact for invocation of statutory extension. That's not a case of renewal. For an extension of the lease to happen by operation of law, ABCD factors are prescribed. One is you should have applied for, it's not a case of renewal. Concept of renewal is different.
Lord, in order to avoid successive renewal, Lord, deemed extension concept.
No question, case of renewal.
Concept has been brought into the statute book. Lord. Even in case of deemed extension, whenever we are doing extension of the earlier lease, Lord, we have to conduct a joint inspection. You
are not extending at all. Law takes care of that. The object of this application, the amendment, is to exclude your intervention because the government is unhappy with the officers. That is the reason section is made.
Lord, that has been covered. This aspect is covered by the judgment of this honorable court. In Anjaneya Reddy, Anjaneya Reddy versus State of Karnataka.
Which year?
Of the year 2020, 5th March 2021, it has been decided. The reported judgment.
This is considered, this aspect.
This aspect has been considered.
Where it's a renewal, we can understand. Where legislature extends the period, it's not a case of renewal. There is some authority for that.
Even in common cause judgment, in case of lease renewal, this aspect has been considered. Every time whenever we are going to execute fresh license. It is not the old license, Lord. We are going to execute the fresh license in form number C. Form number C. In case of leases, we are going to execute lease deed and we collect stamp duty also. And for which, Lord, the separate quarrying plan, EC has to be obtained. Here also, Lord,
Paragraph
paragraph, I'm sorry.
27.
27.
No, the citation.
Engineer.
28.
In that matter, there was a challenge to entire 2020 amendment.
If subsection 2 is applied,
Please.
any format is prescribed for that? Subsection 2, where deemed extension of the tenure of license.
In Form C only we are going to.
Where is the question?
Let.
Where is how that question arises? You may issue so many forms, whether law provides for that.
No, even in subsequent to 2020 amendment, Lord, we have not changed the format.
And then if you have not changed the format, you cannot apply the same format. So that format is prescribed for leases which were granted under the 2012 Act, perhaps as it was originally coined.
Lord, it is just license.
The question of license will not come. Whereby operation of law, certain things happen, your intervention is excluded. That's the object. It fits into separate category, which my lord has said now. It fits into separate category.
That then this aspect has been dealt in common cause judgment also, Lord. You'll ask me kindly have it tomorrow, Lord.
Where is that section we were reading?
6.
2 categories. Amended.
Subsection 5. 2. 5.
What is amended?
Of 2012.
Perhaps this provision will wipe off this requirement.
That requirement also. Correct. Otherwise, they would have said, you have to undertake the fresh access subject to section 6.
It is
stands to
a
logic.
drafter's mistake.
Correct. Oh, we can't say
Then
it's
you
a
can't
mistake
make-
also. It may be policy of the state. Also.
Yes, policy.
But
whatever
policy
it
of
is.
the state is
Policy of
the
in a
state.
better word.
Subsection 2, Mahindra, we
Please.
request you to see it again. It speaks of 3 categories. Licenses that are alive. Subsection 2. And you have sought for renewal. Then you will travel to other provisions, which are the extension of the legislative intention to extend. You need not travel to that at all. You need not travel to it at all. It has to be read out actually. Otherwise, it makes no sense.
So you must switch over your arguments to a different area.
Yes, sir.
You may be right, but
You'll ask me kindly have it tomorrow, Lord. I shall try to, sir.
not tomorrow. Tomorrow, only tomorrow.
One grand principle of interpretation is where interpreting various provisions of a legislation,
Yes.
you should not place such interpretation that one proviso will swallow the other proviso. Yours will go to that extent. If you accept the drafting nowadays, the defect in drafting we have seen, that's the reason why jurists are saying, I am the draftsman of law which contains innumerable flaws. This is kind of state legislation.
So this deemed renewal is not so pervasive that it wipes out all other conditions.
Correct.
That is their argument. So that
Then,
you
my
to
lord,
answer.
but then renewal, my
It
lord,
is not
doesn't.
their argument, it is our query now.
because there's no conditionality imposed in it. Whatever was there, it automatically, my lord, gets extended.
Chief say 6 will not apply at all. Will not travel to 6 because everything remains same. Except everything remains same.
Right.
Because that is deeming.
Deemed.
The statute deems. So deeming should be given full effect. You can't say I will deem up to a particular point and leave rest of the things to our wisdom. That's not the object of any standard.
That is
That's
from Lord, in mining law, Lord, deem means because
not a case of mining, stone crushing.
yeah, of course, Lord,
Mining is miles away.
in the context of Lord, mining, I am submitting. The deeming fiction also coupled with certain conditions. Lord. Otherwise, it leads to disastrous consequences because of this reason. Lord. The quarry plan will be granted for a particular period. That will not hold good for throughout the mining period if it is extended for 30 or 50 years. And easy also for that matter.
That's all.
So certain conditions ought to be fulfilled in deeming fiction also.
They would have said, this deeming of extension shall be subject to reframing of the notification under section 6. It's not the law. Everything remains intact. The purpose of deeming is to assume the existence of certain thing, whether actually that thing exists or not. These are called statute legislative fictions.
Deeming fiction is a bird
Word itself.
which can fly in entire sky.
Not only that, you should not permit it to bog down, my lord,
That's
halfway through. That's the judgment of the Supreme Court. Imagination.
Or day after, one day after.
Whenever we have no object.
consecutive
Day
days,
after
holidays.
is holiday.
I'm sorry.
Monday.
Monday.
Just look into one famous book has come 3 years ago. Law of Fictions by Raghavacharya. One of the best books. A very rare book it is.
Yes.
Yes, on the law of fictions. In our library also. God bless. One minute.
Shrimati HR Renuka, 33.
The original order of dismissal, my lord, was modified by the labor court, my lord, by directing reinstatement with percent back wages, my lord. The award, my lord, was challenged by the corporation in the writ petition. The learned single judge, my lord, has dismissed the writ petition. My lord, the matter was posted, my lord, on 20th of February 2024. The honorable court was pleased to stay the award, my lord, by recording the statement that a sum of rupees 2 lakhs was deposited by the corporation in the execution proceedings and is also been permitted to withdraw subject to the result of the writ appeal, my lord. That was by order dated 22/2024.
Yes, this was interim order.
Yes. And my lord, may I argue on the merits of the case? My lord? He's been reinstated, my lord, and he's working at present.
So what was the period of total service?
My lord, the period of back wages, my lord, is
service.
from 2015.
Service of the candidate.
Total service of the.
My lord, he's at present, my lord, he's 42 years, my lord.
No, joint service when and terminated, dismissed when?
My lord, the dismissed from service, my lord, on 18/6/2015.
86.
18/6.
And he entered into service when?
My lord,
That is one of the relevant.
my lord, he
factors.
entered the service on
Determine the-
2006, my lord. 2006.
10 years.
Yes.
10 years.
10 years.
But what was taken into consideration is that, my lord, he was 42,
But then dismissal is set aside by the labor court.
My lord, that's question, my lord. What, the issue is only this, my lord. He had not issued ticket.
The interim order on
Model
deadline.
is there after hearing.
So now the only you have to
Only with regard to back wages, my lord. Back wages, because he's been working, my
take
lord.
wages, the lump sum.
Lump sum amount
Lump
is-
sum.
But once 2 lakhs is already withdrawn by him, my
It
lord.
is interim order.
Your lordship could close the matter with that, my lord.
But your friend has to be here.
He's not there.
Monday.
Yes.
Kindly, serial number 49, my lord, urgency is this. Tomorrow, Monday or Tuesday, my lord. 49, my lord.
Fish cutting matter. Fish cutting, my report has come, my lord. 38 serial number. Fish cutting matter, my lord, where my lord has called. My lords have called my report from the coastal regulation zone. Please, Monday report has come, Monday.
You are mentioning for second name. Monday. Monday at.
Lordship, serial number 48.
Monday at 2:30.
Your Lordship, serial number 48, they have to get arrears from 2006. So this court directed them to deposit 20 lakhs, still they are not. They are all senior citizens, age about nearly 80 years. Any date may be.
This is a writ appeal filed by the government. And here it is the implementation of the 6th pay. And when is the effective date? And the financial repercussions thereof.
Lordship, that rate.
Should be all,
Lordship,
any
kindly.
dire urgency, then you mention otherwise.
Seal number
All
42.
have dire.
Seal number 42, if I may make a
Item number
mention.
60, my lord, item number 60, medical student, my lord, he was permitted to write the exam. Results
will
have
not-
not been declared. He is
will
not
not
allowed
come. Will
to
not
write
come.
the exams.
Now,
He is not,
this
is
will
not
not,
allowed.
this will go to the another bench, possibly. Check up the roster.
May I make a
Mr. Ravi is saying something.
item number 58, my lord. I made an application for amendment, deemed extension because of the subsequent law, my lord. If that is allowed, I will file a detailed full set of amended petition.
Amendment can be allowed.
Amendment may be allowed, my lord.
Amendment can be allowed.
Lord, you can file your additional statement of objections.
Yes.
My lord, serial number 56, my lord.
We'll take up tomorrow.
Yes, my lord, I'll be-
Tomorrow will be listed, no. Monday, Monday at 11. Monday at 11,
yes.
or if you are agreeable, or
You can allow that application.
It's
You
only
can
a
file your-
formal amendment.
And the contention taken up in the statement of objection, Lord, now they have filed.
Generally, that is done after seeing your statement only.
It's only an amendment, no.
Maybe.
By amendment, I don't
File
get
additional
any relief.
statement of objections.
It's only after your lordship.
all right, we'll grant the amendment.
My
It
lord,
doesn't
serial
change
number
the subject
56.
matter. It doesn't change the anything else, but
No,
adds
no.
to the contention.
And let him file his additional statement if he so desires.
Granting it.
Lord,
Very
serial
Seal number
56, my lord.
42, there is some urgency.
What is it? About-
Seal number 42, recruitment to the posts of train drivers have been held up. I had made this mention last week, therefore it was posted to today. It can be taken up in the next week any day.
It can wait for 10, 15 days.
That's serial number 48. that is-
When one is, minimum courtesy is, when one is speaking, others should not put.
Can
the
wait
minimum.
for somewhere in the
Next week or in the week after next.
next week will not be possible, 22nd of April. Earliest we are giving. Yes.
In interim order may kindly be extended.
Then why don't you go beyond vacation? Enjoy the interim order. Beyond vacation.
Did not reach, my lords, if matters which did not reach, the interim order is operating if it's extended. That's.
Serial number
My lord, serial number
11, my lord.
56, my lord.
My lords, with your lordships, kind leave, my lords.
Requires some urgent relief any date next week along.
IAs are not put up today.
No, my lords, it's
So
come
give
up
number
at
will be
any
put
time.
up along with the next,
Hearing on any date convenient to my lords.
after 10.
Kind indulgence, my lord. Kind indulgence, my lord.
My lord, serial number 56, my lord.
It will distribute it. Dates
My
will
lord,
be.
serial
67
number
kindly, Monday,
56,
my
my
lord.
lord.
Serial number 67, my lord, the university has challenged the interim order granted by the single judge But after the lapse of the scheme, my lord, he has treated as a permanent employee and directed to pay the full salary, my lord, that has been challenged.
It can vary.
Really, Monday, I have.
No, no, man.
My kind indulgence from 64, complaint is 84 years old.